upon notice to the other side, my lord. But we have received yesterday a judgment by mail saying that is a judgment they are relying upon in the notes. But I have never come across this procedure. Matter has been made CAV. We have cited
to your lordship.
Then, my lord, kindly keep it as to be mentioned. I will take 5 minutes to distinguish it. This is my humble request. Or alternatively, I will file a one-page note.
Yes, I think that.
File
a one-page note.
Dealing with
You
it.
deal.
I'll come and mention and say one word on that judgment.
File a one-page note. The same will consider that.
But there is a single bench of Delhi High Court which has not considered the Supreme Court judgment. And this judgment is a later judgment, which my learned friend cited.
That we have not relied
Just-
upon
just,
it when we were making
one
the
page.
submissions.
We'll take
I'll be relying on the principle of par incurium. And, my lord, still, my lord, if your lordship is on that proposition, if your lordship, then, my lord, the principle of committee of courts, my lord, then, my lord, bound by a coordinate bench. These are the two principles, my lord.
Lord, may I have my lords kindly to mention, Lord, at the cost of being reprimanded. Today is item number 51. 59. Lord, I appear for the award holder, Lord. That's a 400 crore award. 34 and 36-2 filed in Jabalpur. I am, Lord, appearing in Jabalpur. Other side is taking time on the pretext that they have filed a 47 here. And, Lord, they are not proceeding the execution as well, Lord. I'm just, Lord, praying that if the matter is not taken up today, your Lordship may kindly keep some precedence, Lord, because, Lord, what is happening? They are taking continuously time in 36-2, Lord, just delaying the process. I'm just praying this much indulgence, Lord.
No.
Your Lordship, this is a very big award. I'm just praying this much.
It doesn't matter to the court.
Yes, Lord, that's true, Lord, but it matters to the award holder, Lord. The award holder is in financial crunch. Kindly considers this.
No.
Lord, we shall wait today, Lord. If not, Lord, we shall mention at the time of rising again, Lord. Kindly allows this indulgence. Grateful, Lord.
Lord, may I mention this matter, my lord? Item 188 of monthly list of December, ECOM number 122 of 2025. I am appearing for the petitioner, and this matter has been settled between the parties, and I have proper instruction for withdrawal. Grateful, Lordship. 155. 188.
Lordship, I beg to appear on behalf of the award holder in this matter. Lordship, a predicament has come up is that the learned counsel appearing is facing certain family medical emergency for which he cannot appear before your Lordship. Hence, your Lordship, if your Lordship may kindly keep the matter next week, Monday or Tuesday, as your Lordship pleases.
These are the changes which
The rectifications, regarding the rectifications. If
rectifications will be carried out, it's just that if you see, you have the order,
Lordship, yes.
paragraph 28. Let us go paragraph 5. Paragraph 5 first.
Lordship. Respondent
So
2.
this is fine. Respondent number 1 will become 2. That's all right. Okay. And as far as the other is concerned, 4 to 8 as second guarantor along with
Nilashish
Roy. There's no need for that clarification. The spelling will change.
Lordship.
Next one. The spelling will change in para 14.
Lordship.
Submission on behalf of respondent number 1 before 17.
Lordship.
That's okay. The other one is the clarification. I think the judgment itself is clear. There's no need for that. On para 25, respondent number 1 will take place.
Para 28.
I think that's it.
Lordship, in para 28, there's another change, Lordship.
Para 28, that clarification I will not give, along with the indication.
Lordship, certain documents, Lordship, needs to be shown. Lordship, kindly keeps it in the next week, Lordship, under to be mentioned.
Faster judgment.
Lordship, I understand, Lordship. It's just
As far as the changes are concerned, if there's any factual error, it's all right. We are not going to hear the parties.
No, Lordship.
Right.
Definitely, Lordship. Just few documents we want.
I'm not going to see documents at all. You want to challenge us? Go and challenge. All right.
I bow down to you.
Beyond this, no changes. Take them. Necessary changes shall be carried out. The changes हैं यहाँ पे. Para 5. Para 5 करें.
Should there's another change in para 31 as well regarding the rate of interest.
Main change. $25. Create more change. Yes,
31.
31 there's a change. 31 is fine.
Eight to eight.
Lordship, this is for a correction of an order dated 27 November 2025. Lordship, previously there was only a order under Order 21 Rule 22. The service had come back as delivered. Lordship, we had to pray for affidavit of assets. In spite of that, we had prayed for warrant. There was no direction for affidavit, so the warrant order could not be passed. Lordship, these are the two orders.
And inadvertent error has crept into the order dated 27th of 2025, wherein at the time of the hearing, the petitioner has wrongly stated that there was a direction for filing of the affidavit of assets. Full stop. There was no such direction. Due to the said factual submission. Due to such wrong factual submission, this court had issued a warrant of arrest against the awarded number 2, Arvind Kumar. That warrant of arrest is discharged. Direction is issued to the awarded number 2, Arvind Kumar, to file his affidavit of asset within a period of 4 weeks. Within a period of 2 weeks, serve a copy of this order shall be communicated to the awarded who shall comply with the direction. Learned counsel for the petitioner undertakes to serve a copy of the order for necessary. Okay. Warrant of arrest stand cancelled. Warrant of not is now standing.
In item number 2, Lordship, your Lordship has been pleased to direct the department to release the originals upon submission of photocopies. If Lordship may kindly record that in the due course of the day, we shall submit the photocopies and we'll get the originals released.
That is fine. The department will do the necessary. The order has already been.
With this, great.
Lordship, item number 4 to 7, all the matters have been settled between the parties. I wish to withdraw the execution application.
Individually take the matter. Item 4. Learned counsel for the petitioner states that the matter stands settled between the parties. She wishes to withdraw the present petition. The same is dismissed as withdrawn. All interim orders stands discharged. stands vacated. If any, all interim orders, if any, stands vacated. Same order in 4, 5, 6. Okay.
4 to 7.
Separate.
4 to 7.
None for the parties. None for the parties. In the interest of justice, adverse orders are deferred. Let this matter be listed in the Excel.
My lordship, award holder is led by Mr. Rahul Arya. He is appearing virtually, Your Lordship.
Lord,
Well,
award
I'm appearing in item 9, my lords, for the award holder.
let a copy be served upon us, my lord. My lord, we have not received the copy. And my lord, one more thing, my lord, we have filed an application, section 34 petition. My lord, what happened, my lord, on 14th November, your lordship was
34 is, it doesn't matter.
yes, my lord, I am just submitting, my lord, on 14th October, my lord, your 14th November, my lord, your lordship was pleased to take up the matter, my lord. When it was our fault, we have not appeared. So your lordship has posted the 34, my lord, in the monthly list of January 2026. Now, my lord, we will be filing an application for stay, my lord, of 36-2, my lord. If your lordship, my lord, kindly grants us some time, my lord, we shall file it. My lord.
That is for you. You should have filed it with your
Yes,
34.
that's, my lord, we should have filed it, my lord.
If you're filing a 34, today it is not an automatic stay.
No,
you know it.
absolutely not, my lord.
So why didn't you file a 36-2 with the 34?
We shall be filing, my lord, lordship.
Execution will go on.
My lord, your lordship, my lord, kindly grants them, my lord, the direction, my lord, to serve a copy, my lord. In the meantime, my lord, within 2 weeks, my lord, we shall file, my lord, the application, my lord.
Hand over a copy, Mr. Arya.
Mr. Mulaj, may I submit, Mulaj, this is an execution which is filed way back on 4th of March 2025. The award is of 7th August 2024. There, they have filed their 34 in around November 2024. Now, till date, my lords, and this is an admitted amount. This 50 lakhs, I had a counter claim. It's an admitted amount by them. I have a simple request, my lords, a short request. Let them deposit the money in court. Let them at least deposit the principal money in court. Let the interest may be deposited later, but at least the principal amount, my lords, let them be, because they have not taken any steps insofar as this procedure.
Lord, your lordship, my lord, generally directs, my lord, for affidavit of assets, my lord. Your lordship kindly grants them, my lord, directs them to serve a copy upon me. Shall file my affidavit of assets.
There is a criminal proceeding also going on against their client, and my lords, they have also chances of being absconder, my lords. The difficulties is they are absconding in a criminal proceeding as well. So I request at least the principal amount may be deposited in the interest of justice, my lords.
My lord, on the first occasion, my lord, it has appeared for the first time, my lord. Your lordship kindly direct.
But your conduct is not very encouraging.
My lord,
you're not appearing in the criminal case also.
My lord, there, my lord, today, my lord, I do not have any instruction to that effect, my lord. Whether there is any criminal proceedings or not, my lord, that is, my lord, submitted from the bar, my lord. I have to take instruction.
They have stated, my lords, I can show in the. They have only
very well
stated
in 34 petition also you would have stated that. It's not that you're not aware.
Yes.
Don't say you're not aware. You're
kindly
Yeah.
grants us 3 weeks time, my lord. In the meantime, my lord, I shall, my lord, file, my lord. But any event, my lord, I shall comply with your lordship's order, my lord. We have to deposit. My lord, let us file an application, my lord, under section 36
The
to, my
Lords
lord.
may see page 31 of the award. 30, there they have stated this, they have admitted that amount. It is not, it's a claim. They have admitted it's a sort of, it's a principal amount which we have given it to them. And it's been lying in that principle from 2018. And
My lord,
I've been
if we
appointed
file an
to
application under section 36 to, lordship passes an order at that time, my
No,
lord.
you do.
My lord, we have
I'm
to
only
secure.
asking the money to be deposited in court. That's
And let this account be, then I'll attach the account.
My lord, kindly consider. My lord, today is the first day, my lord, kindly consider.
That's all right, you come tomorrow with the instruction.
My lord, kindly grants us. My lord,
Sorry, sir, come tomorrow with the instruction.
my lord, I shall take instruction, my lord, as fallen for my lord. My lord, kindly,
If not, I'll pass it on.
my lord, kindly grants us 2 weeks time, my lord. We shall.
I'm not granting you 2 weeks time. You come back with the instruction. Your conduct doesn't inspire confidence in this court. You come back with the instruction Monday.
My lord, kindly,
Monday.
kindly directs them to serve a copy, my lord, at least.
I shall within a course of day only.
Give a copy Monday, not today.
grateful, Millards. Grateful.
Lord, in item number 10, Lord, I appear for the award holder. Lord, in a section 9 proceeding, Lord, post award, Lord, we had filed the terms of settlement. Now, on the basis of that, Lord, the section 9 application was withdrawn. But Lord, at the same time, Lord, this execution was also filed, which does not take into consider the terms of settlement or the repayment, really. Lord, I have to, Lord, withdraw this and file afresh, Lord, taking note of the terms of settlement also. Lord, may I hand over a copy of the order, my lord? The terms were taken on record, my lord. This was a post-award section 9 application.
Learned counsel for the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn.
But with liberty,
With liberty to
file afresh.
File afresh in terms of the settlement agreement dated 1st April 2025. That's the settlement agreement, right?
Yes, my lord. There is a terms of payment and the event of default. So in the event of default, I can file afresh. So I have to take into consideration that and file a fresh application.
Learned counsel for the petitioner states that the matter stands settled between the parties via the settlement agreement dated April 1st, 2025. Full stop. In view of such development, the petitioner does not wish to press the present petition at this stage. The petition is dismissed as withdrawn with liberty to the petitioner to file appropriate proceedings in accordance with law if necessary.
Very well. Right.
Yes,
I appear
Mr.
for the
Sen.
respondent, my lord, award dated in this matter, my lord. My lord, in connection, my lord, with this application, my lord, we had filed, my lord, a section 34 and a section 36 too, my lord.
What is
By
the
an order of
status?
17th of September 2025, my lord, the 36-2, my lord, was disposed of on the undertaking, my lord. They will not proceed with the execution application till such time, my lord, the section 34 was heard out, my lord. May I hand over, my lord?
That's why they're not here.
And, my lord, we have not yet been served with a copy of the execution application. But, Judge,
None appears for the petitioner. Learned counsel for the respondent, award debtor, has handed over a copy of the order dated 17th September 2025, wherein the petitioner has undertaken not to continue with the execution case till the disposal of the application under Section 34 of the Arbitration and Conciliation Act 1996. Full stop. What should we do? Should we just give a date or
my lord, keeps it, my lord, in the list, my lord.
let this matter be listed in the monthly list of February with liberty to the petitioner to mention?
Deeply obliged.
These can be disposed of with liberty to the petitioner to, again file it at the stage, appropriate stage, but nobody is here, so.
Yes, my lord. I bow down. Grateful, my lord. Grateful.
When I appear for the award debtor, my lord. But my lord, I have only, my lord, come up, seen the cause list and come up because my lord, this award has not been served upon the party, my lord, in terms of 31(7), my lord. I believe, my lord, I'm told, my lord, lordship is hearing that matter that's fixed on next Thursday. Whether if it is not served on the party or an advocate or something, my lord, whether it is maintainable or not. But in this matter,
None
my
for the
lord,
petitioner, in the interest of justice, adverse orders are deferred. Let this matter be listed. 21. Monthly list. February. Monthly list, February.
very well.
Or January. Keep it in the January monthly list. January list.
I'm for the award debtor, my lord.
I know.
Lordship, for item number 13, I beg to appear for the petitioner. This is my execution application. This filed beyond 2 years, Your Lordship, from the date of the award. A direction may be passed upon the department to issue notice, Your Lordship.
Learned counsel for the petition states that the present petition has been filed beyond beyond 2 years. Let notice be served under section 21, rule 22 of the Civil Procedure Code. Returnable after 4 weeks. Format and all.
Your Lordship, in item number 14 as well, the same order.
13, 14, same. You have that format for the 2 years. Huh? Order 21, rule 22, CPC, returnable.
Grateful, Your Lordship.
Yeah, appear for the petitioner, National Youth Corporation of India, 15. National Youth Corporation.
টাইম চাইতে বলেছিল
না বলে যাও করতে yes. And this is appearing for the first time. Within time, the execution application has been filed.
You're appearing for the respondent.
with
Learned counsel for the petitioner states that the present application has been filed under section 36 of the Arbitration and Conciliation Act 1996.
Sukumar Bhatt.
He states that the present application is
Bol-
within time. Full stop. Learned counsel for the respondent undertakes to file an affidavit of asset within a period of 2 weeks.
Weeks.
You are for award.
He is also appearing
I'm
with me.
also appearing with me.
Today, first time, my lord, the execution application. Sir, notice maybe. Sir, my injunction.
Have you served them?
No, my lord, first time within limitation, within 12 years, my lord, need not file. Need not serve, my lord, unless your lordship direct and grant injunction, my lord, not to transfer the pending hearing.
Injunction we'll see after they appear.
Did you? The award is at the last page. Your lordship will get it. 18th April 2025.
ये गोपाल तो 2 years वाला जो है within 2 years हाँ उसका एक कोड है
प्रिंसिपल दे दीजिए
डेट चेंज हो जाएगा बस
ग्रेट
Obliged.
Grateful.
वो वापस है ना गोपाल को. $17.
I appear for the award. Item 17, my lord.
Yes.
Yes.
16. Nobody's here. None for the parties. Let this matter be listed in the monthly list. Can it?
Item 17. No, item 17, I appear for the award holder, my lord. The award is within 2 years, my lord. Direction will be given to the awardator for filing of affidavit asset, my lord.
Same order. The video. Date was changed. All right.
Much obliged.
My lord, this is my execution application. Award was passed on 24th of August 2000.
In time.
Within time, my lord. And I'm humbly praying for a prayer A of my tablet statement to file affidavit of assets, my lord.
Within time. Same.
Grateful, my lord. हो गया 18.
I am appearing for the petitioner, your lordship.
Yes, ma'am.
I am for the taking holder, your lordship.
Within time.
No, your lordship. It's beyond 6 years, your lordship. I was served to the other side. This is my affidavit of service.
Yes, ma'am. We've been served, my lord.
Yes.
My lord, today the shoe will really pinch, my lord. I'm praying for an accommodation. My lord, here I'll just indicate one thing, my lord. Here there was a prior proceeding before this honorable court. We firstly have a section 34 on board, my lord. That's still pending adjudication. I'll hand up the AP number, my lord. That can be heard of. One second, my lord. Apart from that, prior to the arbitral proceedings even commencing, my lord, we had already secured a large portion of the awarded sum. So, my lord, today the execution perhaps can't. We'll file our affidavits, my lord. We'll bring all those orders on record. Even the award recognizes that we have deposited. Page 8 of the award itself recognizes that we've deposited a large sum pursuant to orders of this honorable court. My lord, kindly grants us a short time to file affidavits to show what we have done, and my lord will kindly list the AP for hearing. My lord, we'll have it heard out. My lord.
All right, take up. The present application has been filed beyond 2 years. Full stop. Learned counsel for the respondent has appeared. He seeks and is granted 2 weeks' time to file his affidavit in opposition.
Yes.
Let this matter be listed after.
Obliged. And my lord,
I just record that learned counsel for the respondent states that substantial portion has already been deposited. Full stop. He further states that he wishes to place the orders as well as the factual position by way of filing of an affidavit in opposition. Liberty is granted to the learned counsel for the respondent to file his affidavit in opposition within a period of 2 weeks.
yes, my lord, 2 weeks will fine.
2 weeks. Let's start the poll.
One more humble prayer, my lord. Our AP number, if my lord kindly notes that is section
already-
34, it's there.
It is
AP
there,
number 202 of 2018.
Principal
already-
learned counsel for the respondent further states
Okay,
that he has
mention.
filed a section 34 petition AP number
202 of 2018.
202 of
2018, my lord.
It is section 34 pending আছে বলে ওরা
The 2017. Obliged. Be clear.
Section 44 pending.
he wants to file his affidavit in opposition, bringing on record certain facts.
Secure. Orders are-
But that can come in the affidavit of asset. They cannot be in opposition to an execution
Yeah,
application.
it's not a
He's
simplicity.
saying that it's not a simple execution application.
So he can file in his affidavit of assets if he has secured. The only opposition in an execution, my lord, under Order 21 is that of an affidavit of assets. If he has secured an amount, he'll disclose it in the affidavit of assets, my lord.
I'll record it in the other way that the application is saying that the application is not maintainable in view of the fact that the amount has been secured.
If it is not maintainable, my lord, with greatest of respect, my lord, is that, my lord, it would be by way of a section 34.
That's what he has
Also
filed.
there. Yes.
So section, there is no stay. There has to be a 36(2) then, my lord. Otherwise,
Exactly what I want to bring on record, the orders of my lord, prior to the arbitral proceeding, there was already an order passed for a furnishing of security. My lord, that will make our submissions. My lord, if an
But
affidavit,
cannot, my lord, stall my execution.
my lord,
This is
today
an
as
award.
section 34 is there on record. This is a 2018. The award is of 2017. I'm
Also do
seeking
one
2
thing,
weeks.
we'll have it on Tuesday.
Yes, my lord.
You know,
Because 2017 amendment came
whatever
into
you have,
place.
you come.
We'll come with a
Write down the
compilation.
order.
My lord. We'll then come with a compilation of whatever
Yes,
documents
Come
are
back on
relying.
Tuesday.
let them give a copy prior
Because
to us.
next Thursday. Let this matter be listed next Thursday.
Obliged.
Next
But
week,
only thing that he may give us the copy of the orders
the
prior.
copy of the
Yes,
orders.
so that we'll come prepared, ma.
We'll do
Great.
so.
the next Thursday.
Obliged.
Not today,
Thank you.
next Thursday.
Obliged.
Next Thursday.
I appear for the award data, my lord.
My lord, I appear on behalf of the award holder. The award is dated 24th September 2024. So it is within 2 years. My lord, director
Lord, I
may
do
be-
not have any instructions in this matter, my lord, yet, my lord. If your lordship kindly keeps it next week, my lord, I'll come back.
Lord,
You have
director
to
of
file your affidavit of asset.
My lord, whether, my lord, the award was served or not, my lord, that those instructions I do not have. I'm only seeking for a week's accommodation, my lord. Lordship will kindly take it up next week. Lord, I do not have any instruction. My lord, we had
Next
thought
week.
for instruction, we do not have it.
Or next week. Not today,
Take
next
care.
week.
Lord, a copy may be served, my lord.
Just give a copy.
Keep it.
This is an award beyond 2 years. So, my lord, there has to be a service
Yes,
to
sir,
the
will-
department under Order 21, Rule 22, my lord.
Yes.
The order, my lord, the award is of 31st December 2019.
Just take down. The order was that petition has been filed beyond 2 years. Notice to be served under section of order 21. जो
Grateful, my lord.
Well, 22, I appear for the petitioner. My lord, the award
within
my lord,
time.
within time, your lordship, passed on 24th June 2024. My lord, today, my lord, I am praying for an order, my prayer, my lord, under, my lord, prayer B, D and H, my lord, for attachment, for injunction, your lordship, and my lord, for my lord.
Let them file the affidavit. Let them file their affidavit.
Yes, my lord, let them file an affidavit, that is under prayer H, your lordship, for filing of the affidavit of asset. And my lord, till that time, injunct them, my lord, from creating any third-party encumbrance, your lordship.
Not right.
My lord, on the bank account, my lord, and the property, my lord. That will not, my lord.
Let them come back.
Yes, my lord, let them come, my lord. I am only, my lord, securing myself to the extent, my lord,
We'll see that.
let the status quo be maintained.
We'll
My
see
lord.
that, sir. We'll see that.
Prayer H, your lordship, is the affidavit of asset.
Not right now. Petition has been filed within time, within 2 years. Respondents are awardators are directed to file their affidavit of asset. Copy of this order shall be communicated. Serve a copy of this order shall be communicated to the respondents. List after
Affidavit of asset below.
4 weeks, after 4 weeks.
Yes, yes. My lord, in the meantime, my lord, direct them to file their affidavit of asset. My lord. That was deeply obliged. Deeply obliged. Yes, yes.
অ্যামাউন্ট তো দেখি
না কম 16,17,000 Yes, my lord. 23, my lord. I appear for the petitioner. The award is within time. 28th of August 2024. Yes, my lord. Deeply obliged, your lordship. Deeply.
Yes, my lord, my application. The award is dated 21st April 2025. My lord, I'm praying for prayer C as affidavit, my lord.
Within time?
Within time. April 21st.
Affidavit of asset, no?
Yes, prayer C.
Same order.
Great.
Lordship, this is my execution application. This is beyond 2 years, praying order under order 21.
These are all your matters, 25, 26, 27. So 25 beyond 2 years. 26 within time.
No.
Then we have to call out.
Yes.
Call out 27. 25, 26 done.
25 is Lordship Order 21, Rule 22. In 26, Lordship, it's only affidavit of assets.
26 is within time. Affidavit of assets. Next. $27.
27, I'm for the award holder.
Yes.
But not the judgment award data, my lord. Who is the applicant before your lordship?
Within time. Within 2 years.
But it's not an execution proceeding. It's a
What is it?
34 application, my lord.
It's a
34 application, my lord. Oh, sorry. Yes, my lord. My mistake. My mistake. Lord, yes, within time, my lord. Award is dated. My mistake.
What happened? You need a coffee.
No, my clerk gave me a wrong date, brother. But award is dated 10/22nd, 2025. So I am within time, brother. For the past 2 years.
Affidavit of asset.
Grateful.
My lord, I am appearing on behalf of award holder. It is within 2 years. I am seeking direction upon the award debtors to file their affidavit of asset, my lord. These are the details of the amount, my lord.
Award Lignana. Learned Counsel petition is seeking the execution of the award dated 9 June 2025. It's within 2 years. Direction for affidavit of asset.
Yes, sir. My lord, make it returnable, my lord. Let
29.
29, Lordship, this is within 2 years, praying for affidavit of assets.
29 within 2 years. Award dated 14th July 2025. Petitioner is seeking execution of the award dated 14 July 2025. Direction for affidavit of asset. Order to be communicated. 30.
Lordship, 30, I am praying for a receiver on the hypothecated asset, Lordship. The asset is in Howrah.
The learned counsel the petitioner has filed the present petition seeking execution of the award dated. What is the date of the award?
10th April 2025, Lordship.
10th April 2025. Learned counsel for the award holder. The possession of the asset. Schedule A. This is your schedule. What is this?
Lordship, the details are given in the prayer A itself. It's vehicle AL 4825. Lordship, on the tabular statement.
Prayer A. Let a receiver be appointed at a sum of rupees so and so. How much generally is the
Lordship?
Receiver to be paid?
Lordship, receiver is generally paid 25,000 around.
Receiver to be paid 30,000 along with all the other expenses to take possession of the asset being vehicle AL 4825. The concerned police station shall render all necessary assistance. The award debtor shall file affidavit of asset within a period of 2 weeks. Order shall be communicated. List after.
My Lord, this is my application. My Lord, for execution, my Lord, of an award less than 2-year-old, my Lord, the asset is, my Lord, with the petitioner, my Lord, we are paying, my Lord, for appointment of receiver to sell, my Lord, the asset. My Lord, I'm praying for order in terms of prayers A and B, my Lord.
We'll see that, Mr. Sinha, on the next date. Let affidavit come.
My Lord, the asset, my Lord, is already there. So, my Lord, affidavit assets, my Lord, at this stage will not be necessary, my Lord, because the first, my Lord, the asset has to be sold, and thereafter, my Lord. So, if my Lord, Lordship, please, my Lord, pass order in terms of prayer A, my Lord, only, my Lord, public auction, not private treaty. And my Lord, sale, my Lord, will be subject to, my Lord, confirmation of by my Lord.
Let them come. Before I pass this order, let them come.
Very well. Notice there. Very well. My Lord, I can, Lordship can keep it. They are in. कहाँ पर हैं वो लोग? तो छुट्टी के बाद रखना पड़ेगा तो नहीं होगा. Lordship keeps it 1 week after the vacation, because I think it will take us that much time, Lord, to serve.
Petitioner has filed the present execution petition seeking implementation of the award dated. What is the date? 11 June.
Not 11 June 2025.
2025. Full stop. Let affidavit of asset be filed by the respondents. Order to be communicated within 2 years.
And my Lord, liberty, my Lord, to pray for other prayers on the returnable date, my Lord.
Liberty to pray for the other prayers on the returnable.
I'm grateful, Lordship.
Lordship, 32, 33, 34, 35, all within 2 years, praying only for affidavit of assets.
within time. Affidavit of asset.
Lordship, item 36, I appear on behalf of the award holder. Lordship, in this matter, they were directed to file the affidavit of asset. Lordship, subsequent to that, they have not filed it. Lordship, I'm praying for issuance of warrant against awarded number 1 and 2.
This court-wide order dated 7th November 2025 had directed the award debtor to file their affidavit of asset. Full stop. There is no appearance on behalf of the award debtor, neither the affidavit of asset has been filed. Full stop. Let warrant of arrest be issued against the
Lordship,
award debtor.
award number 1 and 2. Matiyar Mondol and Naimuddin Mondol.
Award debtor number 1 and 2. Direction to the police authority to execute the warrant.
Much obliged, your Lordship.
Six to is time. This will take some time. Give 6.
Your Lordship, I am for the award holder. If your Lordship recollects, this is with regards to that issue where the award holder is a sole proprietorship firm and the sole proprietor had passed away.
Oh, yes.
Lord, I've checked up the law, Lord, and to be fair, Lord,
How is that they can?
yes, substitution, it's substitution
fine.
for as far as the carriage of proceedings is concerned. But, my Lord, there is another difficulty, my Lord, which they have to, my Lord, overcome. Lord, may I, my Lord, only refer to section 214 of the Indian Succession Act.
No, but the substitution can take place as long as
Your Lordship,
file an
two
application
judgments.
as far as the
I
carriage of
also
proceedings.
checked that up.
Yes, in
I've checked.
2024, also the judgment that your Lordship had referred, my Lord, there is an exception that is carved out for the proprietorship firm that is with regards to money claim. And here, my Lord, the award is on account of goods sold and delivered. We have a money claim, my Lord.
As if it is
So I'll
not
have
for
to
any
take
personal skills, it can be.
Yes, your Lordship.
But, my Lord, the difficulty would be in their part. As far as the carriage of proceedings is
Correct.
concerned, my Lord, there is no difficulty.
At least let the substitution take place. We'll
Very
see
well,
that out.
because they have to obtain either probate, my Lord, or a letter of admin. Yes, to, my Lord, proceed with the execution.
I'll have to show to your Lordship in summary nature that I am the legal representative by way of that application. If I may prove it before your Lordship, I may be allowed to carry on the execution proceeding. So the necessary steps, my Lord, I need to take.
And I'll take that point whenever it is substituted and comes up, and I'll take that. Because, my Lord, section 214 provides that the court shall not proceed upon an application of a person claiming to be so entitled to execute against such a debtor any decree, unless, my Lord, XYZ are produced.
All right. Learned counsel for the petitioner states that the award debtor has deceased, right?
Your Lordship.
Award holder has.
Award
holder has deceased. She wishes to substitute the legal heirs of the award holder. Full stop. Let the same be done within a period of
2 weeks. 2 weeks. Kindly keeps it after vacation, my lord. We'll,
period of 2 weeks. List after vacation.
my lord. Grateful, your lordship.
Deeply appreciate.
By execution application, there was a direction for filing of affidavit of assets. Lordship, we have served. The service is not clear, Lordship. I was paying for substituted service on the whole.
You are already done through publication.
Once we had done through publication.
Then
Lordship, again, the service is not clear.
says item delivered.
Lordship, but it's not showing at the pin code where the person lives. That's why.
So what you want to again serve them through publication?
We can again serve them and for the award data number 2, Lordship, it shows served, but she's a lady. I have to call the first.
So award data number 2 has been served.
Has been served.
Only award data number 1.
1.
And what is the relationship between 1 and 2?
1 and 2, Lordship. Probably mother, Lordship.
Then he must be staying on the same address.
Lordship?
Must be staying on the same address.
No, they are in different different address, Lordship.
Amit Singh, son of Alok Singh.
But the information is that they are living at that place. They are there at the residence. I can try and hand service and come back, Lordship.
See that?
No.
Learned counsel for the petitioner. 6. 2 weeks time to effect service upon the award data number 1. 6 and is granted. 2 weeks time to serve upon award data number 1. Let this matter be listed after January.
Lordship, I appear on behalf of the award holder. Lordship, on 7th November, your Lordship was pleased to pass a direction of affidavit of assets and directed them to file their asset within 4 weeks. Lordship, they haven't filed it yet. I'm praying for issuance of warrant against awarded number 1 and 2.
Take down. None appears for the award letter number 1 and 2. Both are male or
Lordship, both are male.
award letter number 1 and 2, despite directions to file the affidavit of service. I think they have failed to file the affidavit of service in terms of the order dated 7th November 2025. Let warrant of arrest be issued. क्या वो जो line आता है ना, the police authority to report.
In this matter also, we had previously done substituted service to publication. Lordship, we have again served after the affidavit of assets order. The service is not clear, Lordship. I was paying similar order as in item 38.
Learned counsel for the petition seeks some more time to effect service upon the award data number.
Only one award debtor.
Award data number 1. Learned counsel for the petitioner seeks some more time to effect service upon award data number 1. Award data. I think there's only one. Based on.
One. Even my lord, I am spreading a lot for the lord holder or decree holder, my lord.
Lord, I appear for judgment letter.
What is the APCOM number in this?
Sorry, my lord.
What is the APCOM?
EC, my lord, it should be my lord.
47 of
Is there a AP also?
Correct. 447 of 2020.
No, this is the EC number. What is the AP number? They have filed AP?
Yes, my lord. AP is my lord in respect of my lord the section
What is-
34.
What is the number of that?
27.
27.
Correct. Malad, this matter was listed
Lord,
day before yesterday when learned AG, we are being led by a learned AG. He made a specific request if this matter can be placed on some particular day on a particular time
Well,
when final hearings
Very
can
well,
be.
that's all. Just let me also my lord explain what the matter is. So that my
Particular
lord.
day and there's a particular time when the matters are listed.
Malad, for final hearing, he specifically requested if any of the Monday
You
or
may not
Friday.
but my lord, may I just take 5 minutes of my lord's time? My lord, this is my lord the compilation of orders. My lord, I can show my lord where we are standing now. I have my lord a 3,200 crore award. My lord, there is some protective orders which were passed by court, according to us, my lord, not enough, my lord, for the purpose of my lord execution. My lord, they filed a section 36 where my lord an order was passed, my lord, to directing them, my lord, to deposit half of it and my lord to give bank guarantee for half of it. Challenge before the Honorable Supreme Court, challenge dismissed. Review application dismissed. Then my lord, they have now made an application under section 47 saying that really raising the same points which they raised in the section 36, opposing
No, my lord.
execution of the
Points
order.
are totally different.
Just give me 1 minute, bhai. We're not having a running commentary. We're just, my lord, according to us, my lord, it's the same point which they have raised, saying, we say, my lord, it's a contractual benefit which was given to us by reason of us taking over, my lord, a ailing company, my lord, of my lord, the West Bengal government, Haldia Petrochemical. They say, no, there's a statutory bar with regard to it, and that could not have been given. So this is, my lord, what they have filed, my lord, in the section 47, which is, my lord, what is being heard. That's, my lord, what they were addressing on. We wanted, my lord, to proceed. And, my lord, there are some orders of the Honorable Supreme Court which, my lord, wanted us, my lord, to proceed with the execution.
Page 51 of the
At page 51, as expeditiously as possible, my lord, will kindly look at, my lord, page 51.
Yes.
My lord, 19th May 2025. Then upon hearing counsel, court made the following. Petition arises from order passed by High Court of Calcutta, Commercial Commission, which the High Court said, my lord, we had gone up, my lord, from the execution. Then, my lord, page 53, my lord, will find paragraph 2, Hertz and such, where are the views since the matter is now coming up. Paragraph 3, before the High Court on 13 June, we should not disturb the arrangement made by the High Court as reflected in impugned order. High Court has done well to protect the interest. Application section 34, Sansach. Pending impugned order can be passed in proceedings. Then, my lord, we request High Court to see to it. Proceedings are taken up for hearing on 13 June, and as far as possible, here both the sides recite the issue once and for all. on 13 June 2025, let the court concerned take up the proceedings and pass an appropriate order in accordance with law the earliest. We're informed that so far as Section 34 proceedings are concerned, is before a different court. For the present, we are not saying anything so far as Section 34 proceedings are concerned. Because not having deposited, our case was that you really can't enjoy the protection which is afforded to you under Section 36 without making that deposit. This is, my lord, really the issue. And, my lord, it is probably, my lord, or my lord, not probably, my lord, but it is the largest, my lord, industry, my lord, in the state of West Bengal. Which is, my lord, surviving.
My lords, after this Supreme Court order, there were continuous hearings that were being held. Even this honorable court has passed order where it has been recorded that counsels were heard. My lords, I am also being led by Mr. Jishnu Saha online.
Where is he?
He has logged in. My
It's an
lords.
award. My lord,
For the state?
He's for WBIDC, my lords.
Award dated, my lord, 18th September 2023. And, my lord, by quite a, not that it should not, but, my lord, quite a, my lord,
Huge.
the tribunal, my lord, is quite, my lord, at least, my lord, we thought, my lord, it was quite powerful tribunal, my lord. With, I think, two, my lord, former Chief Justice of India, my lord, it's quite a. So, my lord, we'll find, my lord, in the compilation, my lord, the first order is at page 1, my lord, we'll find. This is where, my lord, the section 36, 2, my lord, was disposed of. And, my lord, we'll find, my lord, and considerable in-depth arguments were made, my lord, according to us on the same points. My learned friend may or may not agree. My lord, at page 40, my lord, we'll find page 40, paragraph 57. Considering the above, this court is not satisfied that petitioners have made out any prima facie case for grant of unconditional stay of the operation of the award dated 18 September 2023. The petitioner is directed to secure the entire awarded amount with registered ordinance in a period of 6 weeks. From date, 50% of the awarded amount shall be transferred through bank in the account of the registered ordinance at this court, and the registered ordinance and receipt of the said amount shall invest in an interest-bearing fixed deposit, National Bank, remaining 50% awarded amount by way of bank guarantee within the time period mentioned above, awarded 18 September 2020 shall be stayed. Date of securing of the total amount awarded, amount as mentioned above. Petitioners fail to secure the awarded amount, award holder shall be take steps for enforcement of the award in accordance with law.
So did they comply with this order?
No, that's not why we are here.
We have given the affidavit of assets where
That's why we are here.
the honorable court has
It has to proceed,
categorically
my lord, with
stated that all the
execution.
assets that are disclosed are sufficient enough to cover the award amount.
Sell the assets to recover the money.
My lords,
Now we are not in the stage of, my lord, giving.
You can't have this order and not comply with it. You have to comply with the order, otherwise we'll go ahead with the execution.
my lords, if I can just point out.
Whatever your assets are, we'll appoint a receiver, we'll start selling.
Yes, that's what, my lord, the execution.
My lords, that is subject to the hearings, my lords. If learned AG.
Execution, what hearings you're talking about? This is what it has been done.
My lords,
Get the award set aside, otherwise the execution, I'm not looking into the merit of the matter. Mr. Banerjee.
My lord,
my lord, if we can.
My lord, we want to proceed. My lord, if they want to, my lord, make their submission today, tomorrow, whenever, my lord, it's convenient, my lord, for court. My lord, kindly, my lord, fix it. And I will show, my lord.
When is the Advocate General available?
My lords, he has told 15 and 16. My lords, can keep this matter on that day and
15th, 16th.
17th.
At
my lord.
17 and 18 would not be possible. Can we put 19th?
19th.
We can do 19th.
My lord, if it comments to, my lord, if it.
19th.
Oh, Friday. No, Friday. 15, 16, my lord, I have some difficulty, my lord. I'm not here, then, my lord, I have to join, my lord.
After vacation.
My lord, then, my lord, before vacation, my lord, whenever he's available, let him, my lord, start the matter. Because otherwise, my lord, this matter has been, my lord, going on. But, my lord, I'm sure, my lord, whatever points he has to urge, my lord, will be considered. My lord, let me put this, my lord, in the. My lord, next week possible?
Next week, it would be a little difficult.
Mr. Shah is also there.
Can we do 19th?
Well, Mr. Shah.
19th, my lord, is not.
19th won't be possible.
Was not possible. No, that's too late.
That would be.
When?
22nd.
Malad, subject to Malad's convenience, I don't know, Malad, that it's too close, Malad, to the perhaps to the
Too close to the
vacation.
We can try.
Then, Malad, if Malad can put it, if Malad it's convenient for Malad to put it on the 15th, 16th, kindly put it, Malad. We'll be Malad there. I'll be there virtually. My juniors can be here, Malad, and let them start.
18th, you have some difficulty. 18th.
18th, we
They have.
he's little stuck. Malad, can it be 19th or
no? You're
16th, Malad.
Then let it be on 22nd. 22nd. At the request of the parties, let this matter be listed on 22nd.
Malad, at the request of Malad,
At the request of the learned counsel for the respondent, the award debtor, let this matter be learned counsel of the respondent states that
Malad, can I
the Advocate General is in difficulty. He prays for an adjournment. Full stop. He states that the Advocate General will be available on the 22nd. Let this matter be listed on the 22nd.
Malad, I'm sorry, Malad, I'm making that request. Malad, if he's available on the 15th, 16th, Malad, kindly put it on the 15th, 16th. Malad, we have no difficulty. Malad, let him start. Otherwise, Malad, this will never.
22nd. Yes.
Malad, is it my Lord's pleasure, Malad, we come back at some point of time, or Malad, 22nd, Malad?
22nd.
Called, Malad, no. Yeah, time fixed. Malad, no time, Malad.
Not fix the time.
Very.
It never really works out.
Very
Jokes my board, and then
just Malad to ensure Malad, the Advocate General Malad is not also in.
That's why I recorded.
He's there, so.
That's why I recorded on his request. 22nd.
So Malad, he's there on the 22nd. That's all, Malad. I'm grateful. Grateful, Malad.
Next.
Hmm? 42, Malad, I appear for the judgment debtors number 3 and 4. There are 4 judgment debtors and 1 partnership firm. So not 5 in total. Malad, I represent 2 of them. Now, there are other set of partners, Malad, who are not represented. Malad, on the last occasion, Malad, I had raised a preliminary question with regard to the maintainability of the execution proceedings. Malad, this is not a normal award which is put into execution in terms of section 36. Malad, this is a settlement which had been entered between the parties and subsequently rescinded by one of the parties. Thereafter, Malad, another mediation had started, but Malad, finality was not there. So today, Malad, the preliminary question, once a party, Malad, to a settlement agreement, if that party had rescinded by way of a letter, I'll show that letter to your lordship, that's annexed D, then perhaps, Malad, this is not a settlement within the terms of section 30 of the Arbitration and Conciliation Act, and therefore, Malad, it cannot be acted upon. Now, that's the preliminary question, Malad, your lordship will decide. Now, kindly have a look at, Malad, the termination letter. Page. Now, termination letter starts at page 27. 26 rather, Malad, 26. 26 is the name of the parties. And before that, Malad, I want to show to your lordship the terms of settlement, Malad, which is put into force to be enforceable before this court. Your lordship will find there are 2 terms of settlement. So the first, Malad, which they want to put into force is at page 21. That is annexed A. Malad, kindly marks the date, Malad, it's a settlement dated 28th of June 2023. Thereafter, your lordship will kindly take up.
Wait a minute. Where is the date? 28. This 28th.
Last
June
paragraph, your
20.
lordship will find
Yes.
the parties here to subscribe their respective
Mediations. Yes.
hands.
The pre-institution mediation.
Now, this is the first settlement agreement, my lord, which they want to enforce today by way of an execution. Now, my lord, kindly sees thereafter page 24. That's the next C. In the initial settlement agreement, my lord, the parties agreed at a sum of rupees 52 lakhs. Now, my lord, kindly comes to the second settlement agreement. My lord, the proposal is now enhanced to 54 lakhs. But what your lordship will not find here is the authentication by the mediator. Now, my lord, this is on 3rd day of July 2023. Now, this is just
So
5 days.
What was the need for going for the second round?
Yes, that is what, my lord, they need to answer, because, my lord, the terms between the parties change, and that your lordship will find from the termination letter itself.
Where is that?
Now, my lord, kindly comes to the next page, page 26 onwards.
First settlement is June, then the second settlement is
5 days later, July 3rd.
And when
And now, my lord, the termination letter comes in August 2023.
No. In between, since you are making the statement that the first settlement is June, the second settlement is May, first is May, second is June. In between, is there any communication?
No. Now, my lord, kindly sees the termination letter.
Please tell me, what is the reason for the second settlement? If this first settlement has already been arrived at between the parties,
It was wrong. It was wrongly done. Yes,
is there
and
any communication to that effect that we are entering into the second settlement?
no, there is no communication on record.
So how did you approach the mediation center?
No, sorry, the second settlement was not with the mediation center. The second settlement was between the parties, signed by the parties, not by the mediator. It's done wrong. It's a wrong action on my part.
Kindly have a look at page 24.
I know. I'll answer to this. It's a wrong action.
Yes.
Now, my lord, kindly comes to the termination letter. No, that's the point.
11th August.
11th August, my lord. Page 27, my lord, your lordship will find in the nomenclature, termination of the terms of settlement dated June 28, 2023. So they are referring to the first settlement agreement, which was actually authenticated by the mediator or conciliator. So, my lord, they are calling off this termination. Lord, kindly sees, Lord, they have assigned their reasons as well. Kindly comes to page 28. Consequently, thereafter, a meeting was held in my client's corporate office wherein it was agreed, acknowledged and admitted by you. You shall clear the outstanding due amount such and such on or before December 22. So now, my lord, thereafter these terms were settled. Now kindly comes, my lord, to the last portion. Well, this is very important, which they admit now, my lord, cannot be called as a wrong action when a lawyer has sent this letter upon instructions, my lord. Under the said terms of settlement, your lordship will find it at page 31. The answer to your lordship's query. My client was agreed to settle on rupees 52 lakhs, which is the terms of the first settlement, which was later rectified to rupees 54 lakhs. My lord, kindly marks this, which was later rectified to on mutual consent on certain agreed terms and conditions as contained therein. A copy of the said terms of settlement with rectification, both dated June 28, 2023, are attached herewith for your ready reference. So the moment, my lord, they say that the 28 June 2023 terms are rectified, so, my lord, it does not stay. So then, my lord, it automatically becomes the subsequent settlement agreement, because it is their case, not my case. Now, my lord, kindly moves forward. Kindly sees, my lord, under the clauses of this said terms of settlement, it was specifically agreed, acknowledged, admitted, and confirmed that any act to diversion and or dilute shall be constituted as default, and you shall pay compound interest of 18% per year to my client to the total settlement amount of, that is 54 lakhs from, so my lord, they are deviating from their stand, my lord. They are no more claiming 52 lakhs in terms of the settlement agreement which they propose, my lord, to enforce today. They are, my lord, going to the subsequent agreement which says 54 lakhs. And the whole amount shall become immediate due and payable at once. Now, my lord, the particulars have also been given. Your lordship will find in the particulars also 54 lakhs is the principal amount, my lord, which they state. It's not 52 lakhs, my lord. Now, my lord, in the last paragraph, your lordship will find, in the circumstances as aforesaid, I, on behalf of my client above named, terminate the terms of settlement dated June 28, 2023 with immediate effect and call upon you to pay the entire amount of 52 lakhs together with further interest thereon at the rate of 18% per annum to my client at the earliest and positively within 7 days from the date. Now, my lord, comes the interesting part. In default, there is a default clause as well. My client shall be at liberty and always be entitled to receive its actual claim of 78 lakhs odd. I have been instructed to take appropriate legal action against you, both civil and criminal, which you have solely responsible. So, my lord, the settlement agreement, by virtue of this termination letter, as well as the subsequent demand, my lord, has lost its force.
Yes.
So, my lord, it is not a settlement decree or terms in terms of section 30 of the Arbitration and Conciliation Act, which may be enforced in terms of section 36, read with order 21, my lord. My lord, that's the precise, my lord. On facts, my lord, I shall show one judgment as well, a very recent judgment of a coordinate bench of this court, my lord, on similar issues. It has to reach the finality, my lord. Yes, your lordship will first take up para 1 and 2, which are the facts, my lord. These are the facts, my lord. An award following mediation and conciliation by the parties in terms of a mediation agreement dated such and such. According to Mr. Shah, learned senior advocate for the petitioner, the proceedings were in nature of conciliation, mediation, and same resulted in signing of a settlement agreement by the parties. The mediator also signed the same. The settlement had the force of an arbitral award and should be enforced by this court as an executing court. So, my lord, this was the question. Factually, my lord, this was the question before the court. 1 and 2. Now, my lord, kindly comes to the observation part. My lord, I will not trouble your lordship with all the facts. Your lordship kindly comes, my lord, to paragraph 48 onwards. Lord, may I place it?
Yes.
Under the 1996 Act, a settlement can be arrived at after the parties discuss the issues and reduce the decisions arrived at into writing. The agreement signed by the parties shall then be authenticated by the arbitrator or mediator. Under the above provisions, the arbitrator or the mediator can also forward the terms and conditions and invite the parties to deliberate upon the same. If the parties agree, they can reduce the same into writing. Upon such writing, the said document shall be treated as an award and shall attain finality. Here, the documents were allegedly handed over to the respondents by the brother of the mediator. Upon signing the same, the document was handed back to the mediator. A question has been raised on the validity of the settlement. Mr. Chaudhary relied on another letter dated 5th October written by the mediator inter alia asking the parties to release the mediator from the responsibilities under the agreement for mediation and the memorandum of settlement dated September 10, 2024. Now, there are the relevant paragraphs are quoted, my lord, of the letter. Now, my lord, kindly comes to paragraph 49. The terms of settlement agreement should have demonstrated a successful resolution of the dispute between the parties on the terms and conditions voluntarily arrived and without any further need for resolution of disputes. Lord, here I pause for a moment. If there was no termination letter, there would not have been any further requirement for further resolution of disputes. The dispute resolution clause takes away the color of finality from the said document. the way dispute resolution clause has been framed, it does not indicate reference to arbitration can be made only if in future disputes arise while implementing the terms of settlement. Even assuming that a settlement agreement can contain a clause to refer the future disputes arising during enforceability of the said agreement to arbitration, but in this case, the objections on the basis of which the mediator asks the parties to either appoint a mediator or an arbitrator indicate that the dispute should be resolved as per Section 50 of the 1996 Act. Even the mediator was of the opinion that a matter should be referred to another mediator or arbitrator. Now, my lord, kindly comes to paragraph 51. The mediator's view was that the parties should avail of the dispute resolution clause as the respondent questioned the impartiality of the mediator and the very existence of the memorandum of settlement. Thus, under such circumstances, the agreement cannot be enforced by this court under Section 36 of the Arbitration and Conciliation Act, which makes the provisions of Order 21 of the Code of Civil Procedure applicable. It is not available from the memorandum of settlement that the dispute resolution clause was restricted to disputes which may arise during the implementation or enforcement of the terms of the memorandum of settlement. Here, my lord, there is another point as well, my lord, which, my lord, I wanted to indicate by filing an affidavit. My lord, there are two set of partners, rival partners. Today, my lord, the partnership firm is dissolved. Now, only one of the partners representing Davish Shakti, my lord, the partnership firm, was before the mediator. This, my lord, was done after, my lord, there was a debt settlement agreement which was executed by and between the parties.
Yes.
So, my lord, my precise point is, my lord, the moment, my lord, this agreement is terminated, it becomes unenforceable, my lord. And even by subsequent conduct of the parties, my lord, they want to claim the entirety today. And that is why, my lord, once they find out that no, perhaps the entirety may not be claimed, it's better, my lord, to put this into execution. But this stand cannot be taken, my lord. No, these are my legal submissions, my lord.
Yes.
My lord, the first in the line is the terms of settlement, which is on 28th of June 2023.
Yes.
So the first terms of settlement is at page 21, which records that the parties have agreed that a settlement amount of 52 lakhs, page 21, with Lakhotia Metallizers Private Limited and Devi Shakti Products. And the mode of payment was 22 lakhs 550,000 per month, with the last installment of 2 lakh to be paid by the 30th of every month. They pay off. There's a default clause. In the event of default, a penal interest of 18% will be charged. Clause 3. It is signed by Lakhotia Metallizers, Devi Shakti, and the mediator. So this document is signed by them. Page 21. 21 and 22.
So 21 is the first one. There's
Yes,
no
the first
dispute
one.
regarding the
The
first
21 is the first one.
Yes.
So this becomes an award. Now this is a reference under the Commercial Courts Act, and this becomes an award in terms of section 12A5. The settlement 4 and 5. If the parties to a commercial courts 12A4, subsection 4. If the parties to a commercial dispute arrive at a settlement, the same shall be reduced into writing and signed by the parties to the dispute and the mediator. So this has been complied with. Then what happens? 5. The settlement arrived at under this section shall have the same status and effect as if it is an arbitral award on agreed terms under subsection 4 of section 30 of the Arbitration Conciliation Act. So this document at page 21, once it is signed by both the parties and the mediator, it partakes the character of an arbitral award and not a contract anymore between the parties, and not a settlement agreement between the parties. It becomes an arbitral award under 30 subsection 4 of the 1996 Act. Now, I have already, and becomes a deemed decree, because I can execute it if it is not complied with. Now, yes, the parties have thereafter, which I have annexed in my petition, parties have thereafter entered into a second terms. The second terms is not signed by the mediator.
So you are saying that the execution is only for the first term?
Yes. The first term, what I want to execute today is the first term. It is not that I can execute the second term. I am executing the first term, which is a award in terms of 12, 4 and 5.
But by your conduct, you have given up the first settlement.
Yes, madam. Can I? Yes. The question is, by my conduct, can I give it up? Yes. The legal. Now, today, my lord, after a decree is passed, it becomes a decree. After a decree is passed, it is always open to the parties to go for a settlement. It is always open to the parties. Now, Order 21, Rule 1 and 2. Those settlements, how to be acted upon by the parties, to what extent it will be a waiver or a binding settlement. Order, this is CPC. Order 21. So I say the subsequent and the second terms is only a contract between the parties which cannot override the award. Now order 21 judgment. Order 21, Rule 1. All money payable under a decree shall be paid as follows, namely to deposit in court to execute the decree, out of court to the decree holder by postal money order. Otherwise, as the otherwise, as the court which made the decree directs, where any payment made under clause A or clause C of subrule 1, the judgment debtor shall give notice thereof to the decree holder either through the court or directly to him by registered acknowledgement due. Where the money is paid by postal money order through the bank under clause A or clause B, the money order payment, the case may be, shall accurately state the following. So this is done, Mala. So the payment, if you do it, you can do it in court, you can do it out of court also. But when you do it out of court, you should inform us. You should inform the court or by the party directly. Here the payments have been made. I have annexed documents where payment has been made.
Payment made?
Payment has been made, yes. 39, yes, substantial payment has been made. But you made a tabular statement. It is 52 lakhs is the award. They have paid 19.5. Payment has been made. Payment has been made. They have acted in terms of it. And these payments are all coming into 2,50,000 per month. Payments has been made. Tabular statement, column 7. The less paid till date. It is 19 lakhs and odd. My dear man. July. Now, so this payment and the breakup of this payment, I have annexed this is the tabular statement. I have annexed the ledger, page 23. So these payments were made from 28th of June 23, and thereafter it continued till June next 1 year. All bank transfers. The payments were coming, man, in terms of this. Now, the next page is the interest calculation, that is in terms of the award. Now, what I say, my lord, so Order 21, Rule 1 is you can mode of payment by the judgment debtor to the court or to me directly for the money order. Now, what happens if there is a out of court payment? Order 21, Rule 2, where any money payable under a decree of any kind is paid out of court or the decree of any kind is otherwise adjusted. Adjusted in whole or in part to the satisfaction of the decree holder. The decree holder shall certify such payment or adjustment to the court. So this certification must be done in the court, whose duty is to execute the decree, and the court shall record the same accordingly. So if there is an adjustment post the decree, suppose a party has accepted a lesser amount or some properties in lieu of a money decree or anything else which is in variance with the decree, it has to be adjustment to the court, whose duty is to execute the decree, and the court shall record the same accordingly. Here, there is no recording. The judgment debtor or any person who has become the surety of the judgment debtor also may inform the court of such payment or adjustment and apply to the court to issue a notice to the decree holder to show cause on the date of the date fixed. So it becomes as a surety. So what I am on the first part, Rule 2, Sub-Rule 1, there must be a adjustment and it should be a recording by the court. The court should record this adjustment. So now in this case, whatever the adjustment is, and the higher amount, 52 went up to 54. Today is not that I am executing 54. I cannot. I am executing 52 only, which is the decree. And I will place two judgments, my lord, which is saying that this recording of the court is mandatory if you adjust it. Unless you record it, I can always fall back to the parent decree which is passed and ask for execution of the decree. I cannot go for the second one. I'm not enforcing here also. Now, there is another letter, the letter which has my advocate has issued. That letter which has been issued, my lord, I must address on this letter on this letter.
That 11th of August.
Yes. This 11th of August.
Your termination letter.
This termination letter.
So you're terminating what? The first one or the second one?
The first one.
So then what is left after?
Yes. Now the question once again, which I'll answer, my lord.
Yes.
Can a decree be terminated? Can an award be terminated? Legally, can it be done? An agreement between the parties can be terminated. The second one. The first one is an award. A decree, deemed decree. So it has been done. It has been done, my lord, before, whatever it has been, I have to go with. I have not suppressed this. Now, I went and I terminated it. So, can I terminate a decree? And can I terminate an award? Now, here also, my lord, the opening line is regarding termination of it. So, I say it cannot be done. The only way is Order 21, Rule 2, the adjustment. That is the only way. And if that happens, the challenging this by way of Section 34 was always open. On the contrary, they have acted in terms of the award by paying me off. Now, this letter, my lord, this letter further records, which my learned friend has indicated, this records that there is a settlement of 28th June at page 31. The second para, at page 31 it records. It says which was later rectified to be 54. The component, my lord, the 52 became 54. So the second terms stuff, and a copy of the terms of settlement with the rectified both dated. This is wrong because both are not dated 28th of June. The second is 3rd of July. The second one is. Now, the next para. Recently, my client at page 31 only. Recently, my client informed from reliable sources that you are rapidly disposing of your properties, assets with fraudulent malafide intention with ulterior motive to defraud my client and attempting to escape your liability in terms of the settlement of 28th of June, which is the first one, the award. Moreover, an attempt to avoid your admitted liabilities with a pre-planned act have shut down, then closed down your factory and attempt to liquidate the asset. I say that you have page 32 that you have defrauded the money, and here, yes, I have claimed on 54. But I say this letter legally cannot be looked into. If I put it, we're allowed to put it in this way, because I cannot terminate an award, I cannot terminate a decree. What can be done? It can be, adjustment can be done under Order 21 Rule 2. That is the only PML. And this letter also says, which my learned friend has indicated, madam, at page 33, that in the event of in default, my client shall be at liberty and shall always entitled to revive its actual claim. The actual claim was 78 lakhs. That I am not doing. Even if I want to do that, civil forum, civil suits are there. I am not doing this. Now, judgment. 2000 টা দিয়ে শুরু করবো, হ্যাঁ 2000। Yes. Now on order 21, rule 1 and 2, my lord.
Yes.
Now, Lordship is already in the Civil Procedure Code. Lordship will also see, my lord. Order 21, Rule 2, Sub-Rule 2A. Sub-Rule 2A. No payment or adjustment shall be recorded at the instance of the judgment debtor unless the payment is made in the manner provided in Rule 1. Rule 1 is recording before the court. The payment or adjustment is proved by documentary evidence. The payment or adjustment is admitted by or on behalf of the decree holder in his reply to the notice given under Sub-Rule 2 or Rule 1 before the court. A payment or adjustment which has not been certified, not been certified or recorded as aforesaid shall not be recognized by any court executing the decree.
Yes.
So, Sub-Rule 1, 2A and 3. So the second instrument, the agreement between the parties, is not an award anymore, and it under there's a clear bar: the payment or adjustment is not certified by the court in the aforesaid manner shall not be recognized by any court executing the decree. And when I am executing the award, ভালো ভালো কপিটা দাও, এইটাই ভালো কপি। Paragraph 7 onwards তো 6 থেকে দেখাই, দিচ্ছি না দিয়ে না, দিয়ে কপি দিয়ে আমি এখান থেকে পড়ছি, তুই বড় হ্যাঁ, আরে দাঁড়া না, পড়তে দে না, শিখতে দে না একটু বাবা। কি plastic. Now here the issue once again arose with regard to that, the same principle of Order 21 Rule 2, 1, 2 and 3. Now I'll take your lordship through the facts. Now on page 241, এই কপিটাই আছে তো, দেখি 241 পৃষ্ঠা থাকবে না এখানে মনে হয় না? Yes, on 241 in the middle, in the head note only, I'll take your lordship. No?
There's a tenancy one.
Is a tenancy one. The tenancy one first, but the parties now entered into a second. I'm on the principle that if you adjust this and how this adjustment should be recorded by the court, and if it is not recorded, what is the effect?
So tenancy dispute, did they approach the mediation center or what?
No, it was not approached before the mediation. It was not approached before the mediation. Now, if you lordship at page 241 in the middle, before the Supreme Court, it was contended. Because it was a decree of a court. Before the Supreme Court, it was contended on behalf of the appellant that one, the compromise had not been resulted in extinguishing the decree. 2, it had only postponed its execution. 3, that on failure of the respondent to vacate the premises at the end of the third year, the appellant is entitled to have the decree executed. It was also contended that as the executing court had not recorded the compromise under Order 21 Rule 2(3), the court could not recognize it and hold it on the basis the decree has been extinguished. Now, paragraph 6, my lord. After the contentions are recorded of the respective advocates, the 3-4 paragraphs, my lord, in this judgment, but only on the point that whether paragraph 6, in view of these contention, the point that arises for consideration is whether, in view of compromise entered into between the parties and executing a new lease deed, the ex parte decree dated 1990 got extinguished, and as such, the appellant cannot get possession of the premises by executing the existing decree. It may be pointed out here that after the rights of the parties are crystallized by passing a decree by a competent court, in law they are not precluded from settling their disputes outside the court. But to have the compromise recognized by a court, it has to be recorded under Rule 2 of Order 21. The consequences of not having it recorded is contained in Subrule 3 of Order 21. And then Rule 2 and Rule 3 are quoted. Paragraph 8. Subrule 1, Subrule 2 noted above requires that any money payable under a decree is paid out of court, or the decree of any kind is otherwise adjusted in whole or in part to the satisfaction of the decree holder. He shall certify that payment or adjustment in court which is to execute the decree, and the court is enjoined to record the same. Subrule 2 thereof enables the judgment debtor or a person who has become the surety for him to inform the court of such payment. Is not in our case, my lord. Subrule 3 prohibits any court executing decree from recognizing a payment or adjustment which has not been certified or recorded by the court under the aforesaid subrules. This court, after reviewing the entire case law in Sultana Begum versus Premchand Jain, laid down as follows. It is head note of the SCC is good in Malay. It is open to the parties, namely the decree holder and the judgment debtor, to enter into a contract or compromise in regard to their rights and obligations under the decree. If such contract or compromise amounts to an adjustment of the decree, it has to be recorded by the court under Rule 1 of Order 21. An agreement or contract or compromise which has the effect of extinguishing the decree in whole or in part on account of decree being satisfied to the extent will amount to an adjustment of the decree within the meaning of this rule. And the court, if approached, will issue a certificate of adjustment. An uncertified payment of money or adjustment which is not recorded by the court under Order 21 Rule 2 cannot be recognized by the executing court. In a situation like this, the only inquiry that the executing court can do is to find out whether the plea taken on face value amounts to adjustment or satisfaction of the decree, wholly or in part, and whether such adjustment or satisfaction had the effect of extinguishing the decree to that extent. If the executing court comes to the conclusion that the decree was adjusted wholly or in part, but the compromise or adjustment or satisfaction was not recorded or certified by the court, the executing court will not recognize them and will proceed to execute the decree. The other decision was also cited, madam, where 11, where any execution proceeding objection to the executability of the decree is taken under section 47 on the ground that by virtue of compromise, the decree got extinguished and become inexecutable. The German question that should be asked is whether the compromise was recorded by the court whose duty is to record the execute the decree. So here, my lord, this recording, whatever the recording is done, the Privy Council in Oath Commercial 1939 are all quoted, my lord. It further quotes paragraph 13 The same principles of different judgments are reiterated.
14.
Yes, 14. I'll place 14. In a case where parties compromise after the decree, in a case has been passed, the effect of compromise on the executability of the decree depends upon the intention of the parties, which is a mixed question of law and facts and has to be determined by executing court on an application under 47 on interpretation of the decree and the compromise in the light of the facts and circumstances of each case. If on such determination it is gathered that the intention of the parties is to extinguish the decree, and either the decree holder or the judgment debtor got the compromise recorded under Rule 2 of Order 21 by the court whose duty is to execute the decree, the execution of the decree cannot be proceeded with by the executing court. But if the intention of the parties is to keep the decree alive and to give effect to it in the manner agreed upon between the parties in the compromise, the decree will be given effect to, accordingly executed as depending on whether the compromise recorded by the court as aforementioned or not. So the intention and the recording. So here, my lord, it is not that by a subsequent instrument we said that it is extinguished, you need not pay any further. It is, we increased it. And in any event, we are not executing that. The intention of the parties is to increase it further. And I am not executing that. It is not, it is extinguished, nothing is payable. And you kept on paying, the balance is 30, this 39 lakhs or not. Now this is the partnership firm. They sign on behalf of the partners. Now a defense is being taken, is represented by two of the. So we have been served on all the partners. Yes. Now it's the liability falls from all the partners to the liability of the firm. Yeah, judgment document. Now, my lord, one order 23. Order 23 there. And order 23 is the principle to compromise. It can be done. But yes, the bullet. Now this letter of 11th of August records that I have terminated a decree. Then if this interpretation is given, my lord, it will happen that the defendant or the decree, the award data or the judgment data will also start writing letters and terminating decrees. That can't be.
Yes.
So, goose sauce for the goose is sauce for the gander. Now, today, my lord, I say that I have referred to some properties and the injunction not to operate the bank accounts. Whatever other objections my learned friends wants to take, my lord, he has a bank account at Strand Road, which is just behind this court building, my lord, and some properties, and then properties.
Are you saying that it is not a decree?
Yes, because it
How?
has not reached finality.
It has. The first one is a decree. It has attained the finality, can be executed in terms of Order 21. The second subsequent action of yours,
Second melody is not, we are not
it's a
concerned
different
because
thing.
second melody is
He's
not
seeking
authenticated.
execution of the first one, which is a decree. You have to show, if you want to argue that, you have to show that how it is not a decree.
But,
in terms of what?
But what has been cited by my learned friend today?
It's a decree in terms of the settlement arrived between the parties before the mediation. It's a award which has been issued. Award to be treated as an.
But it did not reach finality. That's my.
It has reached finality.
Because I say so, because the moment Malad he says, he goes for another Malad settlement.
Sorry, sir. It has reached finality. Whatever it is, maybe there was some dispute regarding, you became wiser by the day and entered into.
Then Malad, the subsequent termination letter, Malad.
Subsequent termination letter is of the first, the other one. Doesn't really.
No,
matter.
it's with regard to the decree which is to be enforced.
It doesn't matter. Nobody can substitute or terminate a decree.
This is the non-est in the year.
No
question,
legal
Malad.
notice.
Your
can
lordship is
terminate a
assuming it as a decree,
has
Malad.
to
I
be
say that this is not yet a decree, Malad.
It is a decree.
But it is merely a decree.
Satisfy that. You satisfy me on that because according to me, it's a decree.
But may I just file a short supplementary affidavit to disclose certain other documents.
No, you support me on law.
Yes,
Whatever you have to say, it's a decree.
Because I mean, if your lordship holds, my lord, it is a decree.
It's a decree.
And
I'll
if your
hold it.
lordship-
It's a decree.
And if your lordship holds, my lord,
Yes.
I am liable to pay.
Yes,
Then
you're
the
liable.
question, my lord, the question comes to what extent is my liability?
52.
No.
52. Liability is only
No,
to the
my
extent of the decree.
liability is only.
You forget about 54. You forget
No,
about
no,
all.
I'm not saying not that.
Whatever
my
your
liability is only
liability
to
is
the extent
19.
of
You have already
40%.
paid 32. Your liability is
No, no.
32 odd amount.
My liability is only 40% of the entire decretal amount.
Whatever it is, the award or the decree is for 52. You have paid 19.5. Whatever is the remaining 32 odd amount is your liability.
It's the liability of the partnership firm.
Whatever. I'm
saying,
not
only
getting
the liability of the partner.
Sir, I'm not getting into that. You have to file your suits within yourself. Whatever.
Pending. That is why, my lord, I want
Well,
to
I'm
show.
not concerned. I'm the executing court. I'm not concerned with your.
That is why, my lord, I need to show.
I'm not concerned. I'm not concerned with how you recover from who you recover. Execution has to be done.
Lord, there are dispute between the partners.
Let it be.
Lord, there is a debt settlement agreement which has been entered between the parties.
Let it be.
My lord, my lord,
Sir, let it be. Let it be. I'm not concerned. I'm not concerned. What proportionality, how much to be recovered from whom, who's going to pay what is not my concern.
Lord,
you want to address on the decree part, I can give you more,
let me come back then, my lord, next week once.
Come back next week. I'm convinced. I'll pass an order. I'm not recording anything today. We'll have it next week.
So like, we remember? No, obviously.
He remembers everything.
Any day on the next week.
Why, my lord, if I do not succeed?
17th, I'm not there on 17th, my lord.
Thursday, next Thursday.
Next Thursday is.
Next Thursday is what?
11th.
We'll have it on-
Yes. Next Thursday, yes.
Next Thursday. Not today, next Thursday.
Yes. No, she will not record it.
I'm not recording
Permit, my
anything.
lord, may I file? Because in
No,
any
I'm not-
event, my lord, I have to file my affidavit of assets. So they are,
Affidavit of asset, we will file
because,
it
my lord, they
later.
are seeking for attachment of a property.
Then you admit it, then I'll.
No, my lord,
you file
after
your
that, my
affidavit.
lord, as an abundant caution, my lord,
No,
because
you file your affidavit of asset. Very
that,
good.
my lord, we shall.
I'll record this. That
Not
then I'll
now, my lord,
record
if I, my lord,
satisfaction.
if I cannot, yes, if I cannot satisfy your lordship, my lord, then.
You can't have
Both sides of the cake. Can't have both.
You can't have both.
You can't have both.
Wait a minute. Then I'll pass an order. I'll record my satisfaction. It's a settlement which is an award to be treated as a decree.
Yeah, my lord.
And then I'll pass an order. Then you file your affidavit of asset if you want to.
Yeah.
But the moment I file, my lord, I admit it's a degree. That is why my learned junior is saying that.
My
you
lord
will
is
file an
helping.
affidavit. I don't know, I cannot.
Oblige, man. We'll come back on next Thursday. Oblige.
ये फाइल भिजवा देना.
This is my execution application. It has got settled, my lord. So lordship can dispose it off. We got the money, my lord.
All right. Learned counsel for the petitioner states that the present matter has been amicably settled between the parties. He wishes to withdraw the present petition. The same is dismissed as withdrawn.
Great.
All interim orders, if any, stand
If any.
vacant.
Great.
This matter, I appear for the judgment debtors, Your Lordship. There was an order on our clients, Your Lordship, to file our affidavit of assets, Your Lordship. We are in default of complying Your Lordship's order. I was just humbly praying if 2 weeks' time could be
Why
granted.
2 weeks? 1 week. You have already
Lordship, the
taken 2
clients are
weeks.
based out of Patna, Your Lordship.
Patna is not that far.
I will take the point of jurisdiction. They have tried to get
You're for the award.
Okay. I am leading Mr. Burley. How do they get the jurisdiction? Lordship, kindly see what is their pleading on jurisdiction. Page 11, para 43.
That, Mr. Mithra, you should have pointed it out to the court on the very first date.
On the first day, it was ex parte, so
There's
it was
there's a direction, I think, which
first day is ex parte order.
So I'm coming, this is the first
I will read the
opportunity. Paragraph, page 11, paragraph 42 is how they create jurisdiction. This is not section 39 of CPC. Page 11, paragraph 43. 43. Where the place of arbitration, that is 42 jurisdiction, section 42. This is 36 and CPC. Respondents are within and they're given the address in Bihar. How can the address given is Bihar? And we don't have anything here. But of course, my instructions were, if they were agreeable to take the principle, I would have
You're not here, we'll keep it next week. And in the meantime, you file after 2 weeks, you file your affidavit of asset at least.
Can you give us 2 weeks?
Yes, the learned counsel for the learned senior counsel for
Can
the
you note my
award.
objection on jurisdiction?
Yes, award debtor seeks and is granted further time of 2 weeks to file his affidavit of asset. Full stop. Learned senior counsel states that the present execution petition is not maintainable since the parties have since the parties don't have any asset,
nor do they have any office.
Nor do they have any office within the territorial jurisdiction of this court. He further states that there is a mere averment regarding the territorial jurisdiction of this court in para 43, which does not suffice to impress upon the territorial jurisdiction of this court. Full stop. He states that the award debtor is located in Patna, Bihar.
That is the address they have given in the course title, that is in
Patna, Bihar.
Jain Nagar, Bihar.
Patna, Bihar, and that
Muzaffar in Bihar.
The present
one address they given Muzaffarpur, one they've given Jain Nagar.
And he raises the point of maintainability of the present petition. None appears for the award holder. Let this matter be listed after 2 weeks. We'll take this issue on the next.
Lordship, may it be listed after winter vacation because after 2
I'm
weeks.
sorry?
Your Lordship, may it be listed after winter vacation because after
After winter, as you wish. After change कर लेना.
Great.
45. Your Lordship, I would be raising exactly the same point, but I have a better case. I have filed an application, demerit application. I have never received the signed copy of the award. It's a 2020 award.
Nobody is here.
Nobody is here. So
let's keep it after the vacation then.
As Your Lordship gives a direction at least for them to file their affidavits if required in the meantime, because otherwise then they will. I just want to get this off.
Let me see the file. A file. Gopal. You have filed an application?
Yes. This is an MSME award. This is an MSME award. What has happened in MSME awards, what was happening before was that they were giving awards with saying true copy, not signed copies. The plethora of judgments which I can show, Your Lordship, which say that a signed copy has to be given under section 31.
So they were giving the true copy, but they were not getting it signed.
Nobody was signing. There's no signed copy. This has happened in many matters. Same.
Anyway, none appears for the award holder. Learned counsel for the respondent has filed GA 1 of 2025. Full stop. The award holder is directed to file his affidavit in opposition. His reply to the said application.
Also, there is a
period of
respondent number 2 who was never a party in the arbitration. I don't know why they have added.
In a period of 2 weeks. Let this matter within a period of 3 weeks. Let this matter be listed after vacation.
Much better.
You communicate a copy of this order to the.
Your Lordship, they have not been appearing. I don't know.
Not been appearing.
No, last time or last day also, nobody has appeared.
You will dismiss it.
Your Lordship, both the last 44 and 45, same petitioner.
Same petitioner?
Yes.
He was here?
No. He was the judgment debtor.
Okay.
If Your Lordship sees.
Okay, we'll see it next
Yeah,
time.
next time, if there nobody, I don't want to take anything. Next time.
My execution application, there was a direction for filing of affidavit of assets. Lordship, we have served through speed post, which has come back as addressee left without instructions for all the award debtors. Lordship, we have tried hand service where judgment debtor number 2 has received. There is an endorsement of receiving. Judgment debtor number 3 resides at the same address as judgment debtor number 2, and judgment debtor number 1 is a partnership firm of 2 and 3. So, Lordship, if this is satisfactory, then I will pray for further orders.
You serve them again.
The problem is whenever we are serving through speed post, it's coming back as addressee not there, left, whereas they are staying there. There's only a small endorsement received and a signature.
This has been received by whom?
By award debtor number 2.
How do you know the signature is just?
That's only an endorse. That's why, Your Lordship, I said that if Lordship is satisfied, then only I will ask. Because they are not giving full signature and nothing, just endorsements. I can serve again.
Learned counsel for the award holder seeks and is directed 3 weeks to effect service upon the award holder, award debtors. On the award debtor. List after 4 weeks.
Lordship, here there was a direction for affidavit of assets. They have been only one award debtor have been served. I was praying for warrant of arrest.
Take down. Despite service. Award debtor despite service. And a direction being passed by this court by order dated 25th February 2025. No affidavit of service has been filed by the award debtor. Award debtor number?
Only one award debtor.
Award debtor. Neither has he entered appearance. Full stop. Let warrant of arrest be issued. उसके बाद police station. The SP has been directed police.
Lordship, in this matter, there was a direction under Order 21, Rule 22, Department to file report.
Okay. The report of the department, perusal of the report of the department shows that the award debtor number 1, 2, and 3 have been served. Full stop. There's no affidavit of assets.
There was no affidavit of assets.
Have been served. Full stop. None appears on behalf of the award debtors. Let affidavit of asset be filed within a period 2 weeks by the award debtors number 1, 2, and 3. Full stop. Let a copy of this order be served upon. Let a server copy of this order be served upon the award debtors for necessary compliance. Yes.
Your Lordship, in item 49, I'm seeking for a passover.
Passover by
Lord, I'm the special officer in that matter. I'm supposed to submit my report.
who's there in 49? Petitioner, who's there for the petition?
Mr. Taposh Dotto is there, but he's not here, my lord. I have no.
Not today, next week.
Shri.
This is an award again, my lord, more than 2 years. So, my lord, a notice has to be issued. 16th March 2022. My
All
lord.
right. Learned counsel for the award holder states that the award is more than 2 years. Let notice be issued in terms of Order 21, Rule 22, Civil Procedure Code, वो formatted वो से ले लो. Warrant नहीं है. ये this execution petition है beyond 2 years where notice has to be served in terms of 21-22 and affidavit of asset to be filed.
Grateful. Man.
In both the petitions.
51 also, my lord.
Same.
51 also same order has to be passed. It's more than 2 years, my lord. Date of the award is same. Grateful.
Lord, I am appearing for the petitioner, my lord. This execution application is award being beyond 2 years. So I'm praying for a direction to the
Beyond
department.
2 years, ये same होगा.
And another thing, my lord, the affidavit of asset is to be filed, and the vehicle is not in our possession. So if my lord gives the direction to the disclose the
It's
wherever.
not in your possession. We'll see that. Yes.
As a direction for disclosing the whereabouts of the vehicle along with the affidavit of asset. I mean, in the affidavit of
Affidavit of asset will take care of it.
Grateful, Lord.
Next.
I'm for the award debtor, my lord.
Item 53, my lord.
My lord, there's
Applicant
a,
to file.
my lord, I have filed a section 37.
My lord, here I'm not going to contest what my learned friend is going to say. Section 34 was dismissed, therefore we had filed the execution. They've carried it up in appeal. There's an order of stay on the award again by the appellate court. My lord, we'll take it out of the list, make the matter go out of list with liberty to mention once the appeal is
My lord, can it be till disposal of the section 37?
Same thing, my lord. I'm seeking to have it out of list. I'm not.
Learned counsel for the petitioner states that the award has been stayed under section 37 proceedings.
Section 37.
He prays for this matter to be
taken out of list.
taken out of the list
matter
with
can
liberty,
be put out
with
of
liberty to mention
yes,
at appropriate stage.
my lord, can direct it to go out of list. Let this matter go out of list with liberty to mention. Deeply applied.
Yes, 54.
I am for the petitioner, my lord.
I'm for the award data.
Of
There is a amicus settlement going on.
my lord, I have no instructions with regard to the
Please give me
settlement.
4 weeks time.
I have no instructions with regard to the settlement, my lord, as of today. And my lord, this is an award of 24th of December 2024. The awarded amount, my lord, will find at page 69. The award starts at page 80. Awarded amount is at page 69. It's 25. The principal amount is 25 lakhs plus 1 lakhs of cost. And My lord, I am going to be praying for prayers B, E, and H of the tabular statement, my lord. They have filed a section 36, my lord. There is no stay as of today.
There is applicable.
All right. Take down. The petition has preferred the present execution petition, seeking implementation of the award dated 24th December 2024. Full stop. Seeking execution of the award dated 24th December 2024. Full stop. Learned counsel for the respondent seeks and is granted 2 weeks time to file his affidavit of asset. Let this matter be listed after 4 weeks. Let him file his affidavit of asset. You appear for all the award daters?
There is only one.
Only one?
Only one.
Award dater. Next.
When I appear for the decree holder,
yes,
I have an award against the state of West Bengal, which is now. Lordship, in this execution application, the last order records of 29th of July. 29th of July, the last order records that this is a second execution application. It has been filed pursuant to liberty granted by the coordinate bench on 21st of April in the earlier EC. Accordingly, according to the petitioner, a sum of 60 lakhs was directed to be paid by his lordship within 30th May. In default, the state was directed to pay interest component of 15% per annum on 60 lakhs from 8th of September till the actual payment. Liberty granted to the award holder to file appropriate application in accordance with law. So this was the second execution which we filed. Now Lordship will turn over to the second page. The state of West Bengal gave all sorts of explanation, but end of the day, they wanted their special leave petition. So they wanted to buy out some time, which is a special leave petition from the order of 21st of April.
Yes.
The 21st of April order is in the execution application annexed at page 81. The component of interest was much higher. We agreed to a concession, and the concession is recorded in this order. And so the concession was directed to be paid within a time. Even if you don't pay within a time, then the interest will start. Page 81. It's a long order, Malad. Enforcement of the award of 2009 for a sum of rupees 1.38 crores along with interest of 1.17, 15%. Now, Lordship, since the awarded sum was not paid by the state and there was no challenge to the award holder made an application in 2010 seeking a sum of rupees 3 crores and odd. Now, these are with regard to those pendency of the proceedings, my lord. Lordship will straight can come to page 4, the 84, running 84, which gives a chart of the figure of 1.74, which is quoted. This is the entire, the principal awarded sum along with the interest. Some payments were made around 6 crores and odd, with records, and the balance is 1.74.
Yes.
Then, my lord, now, my lord, we will come to page 86. 11. During the hearing, 358 paragraph 11. During the hearings, senior advocate appearing on behalf of the award holder, in his usual fairness, submitted that even though the award holder is entitled to interest up to 31st of 2025, the award holder is ready and willing to accept an amount of 60 lakhs or as full and final settlement and forego the balance amount on account of interest in view of the long pendency of this proceeding, provided that the amount is paid by 31st of May. In support of his submission, the award holder relied upon a fresh calculation. particulars are set out. So in next page, my lord, the calculations are set out. The 60 lakhs with the interest calculation 92. Now, para 12, my lord, on behalf of the state respondent, submitted that no amount is due and payable. In support of such contention, it is submitted that the state by a letter of 18th of December had repeatedly sought information. There is the bank details of the award holder, but the same was not furnished. 13. In the light of the above, there is no dispute that the state has intentionally and despite the order of the Honorable Supreme Court refused to make timely payment of the award to the award holder. Admittedly, there had been a delay in making payment of 4.74 crores. In such circumstances, the award holder is justified in seeking interest on account of delayed payment. As stipulated in the award, the excuse of the state of not knowing where and how to make payment is absurd and rejected. In case of not furnishing any detail to the less, the state ought to have brought the attention to the court of this.
I see it all the time. Yes, Mr.
Yes.
Sinha, why you are
Now, my lord, from this order, SLP was preferred, which was dismissed very naturally. From 2009, my lord, after the state to get my money, and this money was not paid within the timeline of 8th of September. The default clause in this has now come into operation, my lord. So the figure is nearly a crore today, because it could have been 60 had it been paid within.
Just imagine how the money is being squandered.
And that is recorded in paragraph 15. Paragraph 15, it is recorded.
Look at that.
It's unfortunate, but I'll not. It's probably our inability, that we could not, persuade the court, or explain. But this was a matter, an award was.
Taxpayers' money. Look at the state of West Bengal.
I'll tell you, Lordship, an award was passed, challenged. The challenge was not accepted. The matter came up before the division bench of
That's
this
all right.
court.
Do you see the anguish in the order?
Yes,
on page 87?
I've seen. I'm just explaining what has happened. The award was set aside by the division bench of this court. Again, reversed by the Supreme Court. So, we fought till the end before the Honorable Supreme Court.
But that's also long now.
No, what has happened? My friend is trying to say as if this is the first execution. So, I'm trying to disabuse Lordship's mind about that.
Second execution.
When the matter came up before the Honorable Supreme Court, when the Supreme Court upheld the award, reversing the division bench judgment, an amount of roughly about 4.5 crores was rated to be paid. We paid that amount to the my friend's client. Our understanding was that is in full and final settlement of the claim. They revived an old execution of 2012, where this order of Justice Kapoor has been passed. We challenge this order, the challenge has not been accepted by the Honorable Supreme Court. What I am proposing, we are filing a short application before His Lordship, for extension of time, so that the default clause doesn't come in. But for the time being, this amount, which was rated to be accepted by them, 60 lakhs, I'll pay that within 4 weeks. Your Lordship kindly permits me.
But
the balance amount
exactly was challenged with application we were saying.
Yes.
This amount was to pay on 25th of April.
No, this was 31st of May. 31st of May. We had delayed by 6 months, not because of the
May 2020.
Yes, not because of the SLP we had filed. I'm saying this 60 lakhs we shall pay within 4 weeks. Kindly keep it 2 weeks after the vacation, within which time our will know the fate of our application, which we are filing within a week.
What application?
We want to file an application for extending the time to before Justice Kapoor.
Justice Kapoor after the SLP is dismissed.
Sorry, my lord. That point you take.
Then you make the submission before Kapoor. You, will kindly see.
I'm saying
this order was the Supreme Court was passed in September.
No, there's a default.
Now in November, they contemplate to file an application. This is the action, my lord. When I come before the court, I mentioned this matter twice before this court.
Yes,
my lord. Now they say they will pay this 60 lakhs in another 4 weeks, which will carry another 4 weeks interest. And they will go to Justice Kapoor, and then another round of litigation, another Supreme Court. That is the action. You go to Supreme Court on this count. When September, you lost thoroughly.
You have already challenged the order.
And then another round that you go to Supreme Court, and you'll end up in paying me 1.5 crores. That is the idea.
You are getting the money.
Now, what fell from your lordship, that taxpayers' money.
This taxpayers' money, this is how the state of West Bengal wants to deal with their taxpayers. They want to keep enriching the contractors. Good for them. If this is the manner in which the state of West Bengal deals with their awards, that you keep on paying money where they are not even entitled for, The interest is being looked at what Justice Kapoor has written in his orders.
Not I have noted that. Not
Just
so, not,
read this.
we are trying to not save little money. Not if it is.
Just read, Mr.
Not I've read it.
In
Not I've read it.
conclusion, just a minute. In conclusion, it's a matter of grave concern as to how public funds are squandered by the state. An award for a sum of approximately 1.38 crores in 2009 is still being satisfied, notwithstanding payment of more than 7 crores. You have paid 7 crores interest.
My lord, we lose in every sense. My lord, if we, my lord, may I just say this? My lord, if we pay, my lord, then we are colluding with the contractor. If we fight, my lord, we are procrastinating. My lord, we are hit both ways. My lord, if we cooperate, then my lord, they'll say that there is something different, some underhand dealing. Therefore, you have not all that.
Have to comply by the award.
No,
this
I will.
Money of 1.38 crores running into 7 crores, and today also the award is not being satisfied.
My lord, award
want to file frivolous applications.
No, my lord, my lord, all that I'm wanting to do, my lord, I want to add not the consequence
You
of
have
this.
given commitment to
default
the court
clause.
that by 30th of May you will make the payment of 60 lakhs. Even that has not been done. Interest is being accrued even on that amount of money. Who's paying for all this? Who's paying for all this? The taxpayer.
The amount of 60 lakhs, not we shall pay within 4 weeks.
Why 4 weeks? Pay it tomorrow. Why 4 weeks? Why should I give you 4 weeks?
But it will have to, your lordship not
Wherever it is, Mr. Sinha, you have already taken so much time.
Your lordship may not be.
You come back next week.
Next Thursday.
Come with the check of this much money. We'll see that.
But I know how the finance department works.
Whatever it is,
No, what I'm
then
saying-
we should send somebody to jail. Let's send the finance secretary to jail for some time.
Your lordship may direct-
Let him go for a week.
But we have
He will
filed
make
this in
the
July.
payment. Let the
They
finance
were aware
secretary
of this
go for a week
application
if he can't
pending for
make the
last 6
payment.
months.
We can't tolerate this kind of action on the part of the state where they take us for a ride. This is public money. The finance secretary and the other people are not paying from their pocket. This is going from the exchequer.
Not the player, not this player, not they can get the money from the Reserve Bank.
Sir?
You can direct the Reserve Bank not to pay within a week's time. Not tax.
Yeah,
Not
report be
tax.
filed
But
with
I'm
the
only
Reserve
saying, not can you restrict that amount to 60 lakhs? So not we can just.
Why should I restrict that amount to 60 lakhs?
Because not
The entire amount should be paid.
Not because the amount for the adjudicated. Not we want to-
Entire amount should be paid, whatever it is. If you want to show your bona fide, come with a check of 60 lakhs next week. Otherwise, entire amount has to be paid.
And I'm saying, lordship said 60 lakhs from RBI within a week's time. Lord. There's no difficulty. Lord. RBI will make payment within a week's time. Lord, I'm not opposing that. Lord, kindly direct RBI to pay them 60 lakhs.
Why 60 lakhs? The RBI should make the entire payment.
Why 60 lakhs? It's not a concession.
60
I have
lakhs?
given
You're
a
not making a
concession.
concession.
But then what happens to my concession?
This is
When
not
my
a
senior
concession.
advocate appeared and gave a
You're not
concession.
here to bargain.
We wanted to explain not why we could not pay within.
So if you want to explain, come with
Then they explain to the Supreme Court.
your 60 lakhs within a week. We'll see that. The other explanation we'll take from you after that. You come up with your check. We'll see the other explanation on next week. Whether those explanations are to be considered or not to be considered.
Well, the prayer A is, I think, with the my tablet.
Next week, we take us not to 11, but waiting because keep it on 15. So I'll try my best.
15th.
No, the prayer A, my lord, will, I think, will
15th.
save the Reserve Bank direction and Reserve Bank too.
15th, let them come.
Prayer A.
Learned counsel for the respondent. Learned counsel for the abort data. State, respondent states that they shall come up with the check amount of rupees 60,58,506 on the 15th. Let this matter be
Well, it's a
lifted for
Monday. Lordship is
15th.
15th is a Monday. I think Thursdays are general.
Okay, we'll have it on Monday.
Thursday. Monday.
Next Thursday is what?
No, next Thursday is 11th. The 15th is Monday.
18th.
ठीक है,
Lord, next
ठीक
week,
है,
same order, the figure will be.
ठीक है. Figure to next figure.
99%.
Let's refer for the
Figure will be
consideration. What is the figure in the next
Yes,
one?
52 lakhs, 86,209.
Same order.
52
lakhs,
Figure would be
86,209.
52 lakhs
86,209.
shall come up with the check of Certain such amount listed for further consideration on 18th. Mr. Sinha, please. You're a responsible officer of the court. At least
We try our best, not, but unfortunately, we couldn't not convince the honorable court. They can't reopen those.
we can't reopen, Mr. Sinha. Once it has gone there, now even our hands are tied.
Well, his hands are much longer. He can even control what happens in Delhi. Who appears for me, who makes what submission.
Next. Go on. On the 18th. 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 Order shall come and check on the 18th.
This was the money. This is the case where I want to withdraw the money. That's around 10. Now
11,
today has come to around 10-15% of the award that is lying deposited in court. They have lost up to the Supreme Court.
We have lost up to the Supreme Court to an extent this money is concerned, which is deposited.
Last order records.
Last order records that matter. My lord's last order.
We have served the date of the we have served affidavit of service. Affidavit of service.
Take down. This is GA, right? GA2.
My lord, this is just only one small submission, my lord. I don't because the money was deposited with the side registrar. Whether the money has earned any
No interest.
It has not.
That there was your.
But
The report also says that.
the report says that it was not supposed, it was not directed to be deposited in any of the fixed depositors. But however, the money must have earned some interest.
No,
Because if you keep it in the bank also, it must have
So
earned.
unless until there's a direction for the interest bearing, FDR, I don't think so that anything else can be.
Because whatever interest comes, that definitely goes to my client.
I'll recover from you. Whatever interest comes to the High Court's benefit.
Yes.
Comes to the State's benefit. So it goes back to you only.
Take down. Learned Counsel for the award holder, GA2, has filed the present application seeking withdrawal of the sum of rupees 11 crores 41 lakhs 40,000 lying with the registrar original side of this court. Full stop. He states that the amount is in pro tanto satisfaction of the arbitral award dated 22nd June 2020 as modified on 14th August 2020. This court-wide order dated 27th November 2025 has already noted that the Section 34 APO number 351 of 2020 filed by the award debtor was dismissed on 27/2023. Full stop. The award debtor challenged it further in APO number 205 of 2023. And the same was also dismissed on 12/2/2025. The said order was appealed in SLP number 15878 of 2025. Full stop. The said SLP was dismissed on 22/7/2025. Full stop. In view of the said development, this court is inclined to allow GA2 of 2025. Direction is given to the registrar original side to release the amount of rupees 11 crores 41 lakhs 40,000 in favor of the award holder. Full stop.
Number one.
Award holder number one. Full stop. With the above direction, the present application is disposed of. Should I record your submission?
I have nothing much to submit because the order speaks for itself.
Next.
Lordship, I am behalf of the applicant. I am praying for only not today.
Not today.
I appear for the award holder, my lord.
Yes.
Your lordship, before my learned friend proceeds, my lord, I have two submissions. We have been served with the copy of the affidavit of assets.
Yes.
My lord, according to us, my lord, this affidavit of assets is insufficient, my lord. No particulars have been given. And secondly, my lord, in my execution application, they have filed a section 47 application, my lord, seeking, my lord, stay of the execution. I have another point, my lord, that they have preferred section 34 as well as section 36(2) before the court, my lord, having jurisdiction, that is in Jabalpur. So, my lord, I request, my lord, that, my lord, the maintainability point of this section 47 be heard first, my lord, before dealing with section 47. And, my lord, may kindly seize the affidavit of asset once.
No, my lord, is my learned
If you
friend
have
going to,
already
my lord,
filed
move my application?
No, I'm just saying, my lord, this is the preliminary objection so far as 47 is
Let me
concerned.
move it, then you take the preliminary objection. My lord, let me tell you, lordship, what has happened.
Sir, आगे अपनी affidavit of assets का file कर देना.
My lord, there was a direction from this court, my lord. It was not really a direction to file an affidavit of assets per se. It was, my lord, to disclose the assets. Movable and immovable assets, my lord, that affidavit is there. My lord, your lordship will find that, my lord, the respondent in the execution case is Hindustan Copper. It has, my lord, according to, my lord, the directions of this court, my lord, file an affidavit. My lord, it is not really an affidavit of assets, my lord, in the form required to be filed. My lord, we have followed the direction. I am praying for your lordship's leave to file this. Now, my lord, your lordship will notice that, my lord, the order by which this affidavit was directed to be filed records the fact that we have moved a 34 application. We have filed an application under section 36(2). Independently of that, well, of course, that has to be
this
filed.
order doesn't record that. The last order doesn't record that. It only records that you will be filing 47.
Yes, but I think, well, this is your lordship looking at the order?
24th October.
24th of October.
Yes, my lord.
Yes, my lord, that, my lord, records.
Yes.
That, my lord,
34 you have filed, 36(2) it doesn't record. It only records 47.
Lord, they had submitted, but, my lord, subsequently it was filed before
it was
Jabalpur.
filed, my lord, thereafter. Your lordship is right.
We have filed our
Now, my
objection
lord,
also.
it's like this, my lord, in 36, my lord, I have made a prayer for unconditional stay of operation of the award. 36, my lord, could
Then
not
how
be
is
heard.
this maintainable?
Yes.
No, 47, my lord, is maintainable if I can raise a question of nullity. Only on that question. My lord, the Supreme Court has made it very clear that, my lord, in a 47, I can't, my lord, exceed, my lord, the scope of the application, which must be confined to the question of nullity. My lord, my question of nullity, which I raise here, is a question that was raised before the tribunal.
Application has been filed now?
Yes, yes.
Yes.
My lord, my learned friends have not used an opposition. It is up to them whether they want to file an
First time it's appearing, my lord. Previously
that's
only
right.
EC appeared.
If he wants to file an affidavit, my lord, your lordship, it's, my lord.
Of course
may I-
I'll file, but, my lord, my contention is that, my lord, we will press on the maintainability first.
Well, very well.
I'm
If
being
my
led by
friend-
Mr. Ghosh, my lord. He will address on the
Well, let
maintainability
him,
that.
my lord, does he want to do it today? Does he want to do it on another day?
When do you want
Well,
to
I
do
am
it?
ready to argue even now.
Yes, my lord. Then, my lord, your lordship may kindly grants me leave, keeping the point of maintainability open. We'll file the opposition, and
Very
then your
well.
lordship can take this. But, my lord, so far as this affidavit of assets, my lord, it's my submission that, my lord, your lordship may
This is
kindly
not
see
an affidavit of
paragraph
asset.
4 of the order.
The order only says that you file your movable, immovable
may
in
kindly
the
see
form of
paragraph
an
4.
affidavit.
That's
Yes,
right.
yes.
That's right.
In the form of an affidavit,
Yes.
not affidavit of asset.
My lord, filing of assets in the form of affidavit is affidavit of
There's a
assets.
difference,
my lord.
Well, I think, my lord, my lord, the
that is-
court, my lord, is quite, my lord, clear about what it wanted to be filed.
Yes. There's a difference.
But,
The
my
court
lord,
was
no
quite clear.
particulars. My submission is this affidavit has no
All right,
particulars.
let him file his affidavit of
Yes, my
asset.
lord. That
That's
can
the
be done,
direction.
my lord. That should
Hindustan
be
Copper is not running away anyway.
No, it's not about running away. That's the
No,
procedure. my lord,
anyway,
in
my lord,
execution. They have
if
to
my
file
learned
their
friend wants to file an affidavit, my lord, we
I
should
will
come
file, but, my lord, a direction may be given that they should file their affidavit of assets.
No, then we'll see whether we want to entertain this application or not. Then you
Yes.
Yes, yes.
argue on the ground of maintainability
course,
before
of
you
course.
file your reply.
Of course.
Very well then. Then, my lord, on the kindly keeps it next week. my lord.
Learned counsel for the you're the award debtor, right?
I'm the award debtor.
I'm the award.
Learned counsel for the award debtor. Learned senior counsel for the award debtor. Mr. Saha has filed an application GA 1 2025 under section 47 of the Civil Procedure Code, seeking stay of the execution of the award. Full stop. Learned counsel for the award holder states that the said application is not maintainable since the award debtor has filed an application under section 36(2) of the Arbitration and Conciliation Act,
Raising same points.
raising same contention. Full stop. He states that in view of the said
position, the present application is not maintainable. Full stop. Let the issue of maintainability be addressed on the next date of hearing, which is when you want.
Next week, my lord.
Well, next week, 15th and 16th, I'm in some difficulty.
And then, my lord.
18th?
18th is fine.
18th, my lord, Mr. Ghosh is not there. My leader is not there, my lord.
So January?
Your lordship will
Then
fix
it will go in
your
January.
lordship's convenient date, my lord. I can only indicate when I am in.
Then it will go in January, sir.
Very well.
Then, my lord, on 10th, my lord, can it be?
No. 10th.
Let's
11th, I can have it.
11th and 11th.
11th, you want it?
Yes, yes, 11th.
Mr. Saha?
11th of December. Yes, my lord.
11th?
11th, my lord.
Affidavit of movable and immovable property as per the direction of this court has been filed in the form of affidavit. Immovable and movable property in the form of an affidavit has been filed in terms of the earlier direction passed by this court. Full stop. Learned counsel for the award holder states that this does not include the entire assets of the award debtor. He prays for an affidavit of asset to be filed by the award debtor. Full stop. Let an affidavit of asset be filed by the award debtor within a period of.
Well, we'll file it within 2 weeks.
Within 2 weeks.
Great, my lord.
List on 11th.
11th.
Very well.
You file with other now. Next.
My execution,
yes.
Well, the 37 has been dismissed on 24th of July 25, and I am praying an order for attachment of the Reserve Bank of India account to the extent of the decretal amount.
Lord, I'll need to take instructions and come back, but there's one thing about the procedural part. It's an award of 2000.
Next week, Mr. Sinha.
Award of 2018, my lord.
Next week, too much against you. So next week. Next week.
Very well.
But let there be an attachment of the
what I'm submitting, Lord, may I just say that my friend would agree, Lord, this award notice of 2018, Lord, in notice under order 21 has to be issued by the department. But that's the procedure. My friend will, Lord, agree.
That must have been done long back.
No. That notice has not been issued yet. But that's
my learned friend is appearing. The learned friend is appearing. Let it be recorded.
My friend will not misunderstand.
Dispense with that, you are appearing.
Lord, no, Lord, they were just not this served in my office, Lord. The orders, the order 21, Lord, says, Lord, the notice.
Right, so we will record that. Take
Lord, it says the notice shall be issued.
Learned counsel, the award debtor states that the notice under order 21, rule 22 of the Civil Procedure Code has not been filed.
Has not been issued by the department.
Has not been issued by the department. Full stop. Since the learned counsel for the award debtor is appearing in the court, full stop. He is it's a deemed notice.
Advocate on record for the state of West Bengal. So therefore,
Lord, it says not the notice shall, but I can show orders of this court, but in every matter it has been issued. I know I could have awarded not appearing, but not since I've been served, I'm here to not assist.
Mr. Singh, you tell me, can we dispense with it as a deemed?
My learned friend is appearing.
As a deemed service, Mr. Sinha. You're also here, Mr. Sinha.
And he is one of the advocate on record. I could have understood.
As a deemed service, we can dispense with that. When
Lord, Lordship, can you not say that, my lord? I'll not raise this point, but because that will be, Lord, this will go against this provision.
That's what.
But I'll not say this, Lord. I will accept on this. Kindly keep it after a fortnight.
At the request of the learned counsel for the award debtor, let this matter be listed. On when do you want, Mr. Sinha?
Not a fortnight, 18th, but not on 18th, but the other matter is coming.
I must get the principal amount.
I will.
Right. Let this be also on 18th, but I do not know, because otherwise it will go beyond the vacation. I can't ask for that.
18th. Then I will.
No, I have some sympathy.
Today, even I have, you know.
But I have to look after my client who's standing beside also. Otherwise, they will say that what is the point in briefing is this?
Lord,
The other matter, my lord, again, my lord, state of West Bengal.
There, my lord, kindly, my lord, keep it, my lord, after a fortnight. My lord, there, my lord, what had happened, we have given
Which matter
security.
is that?
Lord, item, my lord, 62. Lord, that can also not appear
These
after.
matters should come up, my lord, slightly at the top, my lord.
Not after a fortnight, my lord, to ho hi jabe.
No, my lord, here, my lord, what had happened, I'll tell you, lordship, my lord, the condition for stay, they did not, my lord, comply.
Fulfill that. He's
Fulfill
same like
that.
the other one.
Not much,
We'll see that.
not much lesser sin here, my lord.
So we'll have it on the 18th, this one also.
Sure. By that time, Lord, we'll have the extension from the applicant.
18th?
Yes,
If
Lord,
at all.
because no. By that time, Lord,
62, right?
Yes,
So
62.
call out 61 first. Yes, sir. Tell.
Award holder in this matter, last occasion, the award debtor number 2 are directed to file their affidavit disclosing some additional documents.
Debtor number 2, I am for the debtor number
Yes,
2.
madam.
My lord, because of his sickness, my client.
All right, learned counsel for the award debtor seeks and is granted one more, 1 week.
1 week, no, my lord, kindly fix it after 2 weeks. My medical documents.
Seeks and is
After 2
granted
weeks,
further time of 2 weeks on the ground of medical condition of her client to file the affidavit of asset as directed by this court. Full stop. Let the same be done within a period of 2 weeks. List after 4 weeks. 62. List after 4 weeks. Within 2 weeks to file. 62, yes.
It may appear after 18.
At the request of the learned counsel for the award debtor, let this matter on the 18th. On the 18th. List the matter on the 18th.
On the prayer of the state.
Yes, that's
yes.
On the
Lord, 9 crore security furnished. Lord, the order specified that 7% extra, Lord, has to be given every year. So, not that 7% extra, Lord, we could not. That is why the order was vacated. Lord, we are ready with that.
State, you should come up with some kind of a method where at least the interest is not being paid for, like, this is a matter.
And these are all contractors of
the matter. MSME, you know, the percentage is 3 times more than the RBI rate. Now it is so easy that somebody will take an award, sit over it. Maybe I don't know what is the intent behind it, but the kind of interest which is accruing.
That is
42 lakhs award goes
interest,
to 24 crores.
This
Yes,
is very,
And
very,
who's paying?
We are paying. Your Lordship is right. We are paying.
I mean, it really pinches.
Absolutely.
Even in the last order, if you see Justice Kapoor's anguish, can be reflected in the order.
Yes.
And every day this is happening in the execution. Then why should people work? They should just
get some award.
Get some award.
Please, your lordship, I'm mentioning a matter.
Mentioning
This
this hour?
lordship, I just an indulgence, lordship of
No,
5.
at this time. Morning, tomorrow.
Much obliged, your lordship.
Judgment. Wait. And for the police. For all the reasons discussed here and above, this court holds that the impugn award does not warrant interference. The petition under Section 34 of the Arbitration and Conciliation Act is accordingly dismissed. उसको दे दो.
Heading number 286. Income 180 of 2024, Cholamandalam Basement versus Mohammad Aslam Ansari.
I am appearing for the respondent.
Lordship, I am appearing for the award holder in this matter.
Only one, Muhammad Aslam Ansari or Niaz Ahmed, both are here.
Both are here present.
Have we got both the yeah?
Affidavit of asset. Malad, here is the affidavit of asset.
Where are the affidavit of
And
asset?
already served. Equal application.
One the page, two the one the page. Mohammed Aslam Ansari.
Yes. আমাকে বলছি যা বলবে সত্য বলবে, সত্য মিথ্যা বলবে।
না,
কি নাম আপনার?
এমডি
নিয়াজ আহমেদ।
এটা যাবে এটা
বাবার নাম মোহাম্মদ আসলাম। মোহাম্মদ আসলাম উনি বাবা।
এইটা নিয়ে কিন্তু কথা হয়ে গেছে
पूरा बंद रोड वार्ड नंबर 12 पूरा बंद रोड वार्ड नंबर 12 पीएस खड़गपुर टाउन
কিন্তু ওরা
डिस्ट्रिक्ट पश्चिम हाँ
না পুরোটা কখনো সেটেলমেন্টে চাইতে পারি বাট with a claim of more than 20
बाबा साहब
that is as per
বলবেন সেটা
as per award interest কিছু দেবে না
আপনার উকিলের কাছে একটা ফর্ম আছে সেটা হলফ
that is as per agreement
বুঝে নেবেন কি
ঠিক
কি
আছে আপনি
করতে হবে আর আপনি যদি না পারেন ঠিক আছে
कब करोगे पेमेंट?
পেমেন্ট কবে করবেন? আপনাকে টাকা ধার মানে টাকা পে করতে হবে, টাকা দিতে হবে, কবে দেবেন? মৌখিকভাবে বলেছিলাম 3 মাস টাইম নিয়েছিলাম যে টাকাটা 3 মাস 3 মাসে দিয়ে দেবেন পুরো টাকা? না পুরো টাকা না, যে যেটুকু কথা বলছিলাম আমি একটু কিছু টাকা ফার্স্ট ইনস্টলমেন্ট হি ওয়ান্টস টু পে উইদিন 3 মান্থস।
पेमेंट करो आप।
পেমেন্ট করুন না ব্যবসা আপনার কাছে স্টেপ নেবেন।
Take down the formatted award letter number 1, award letter number 2 has been produced before the court in terms of the warrant arrest issued on 7th of November 2025. Both has been administered. Affidavit of asset filed by the award letter number 1 and 2 is taken on record. They undertake to appear before this court for examination as and when required. We'll keep it for examination on the next date, madam.
yes sir
In the meantime, talks of settlements are also going on. If that fructify, then
Let this matter be listed for examination of the award letter number 1 and 2. After, if the talks are going on, we'll give a longer date, 6 weeks,
lordship
4 weeks,
4 weeks 4 weeks
after 4.
lordship there is an application that has been filed by them which is also appearing in
recall application, my lord, has already passed the order.
lordship the warrant that
Warrant-
becomes infructuous that can
Warrant
be
of arrest has
disposed.
been discharged. Application recalling the warrant of arrest, GA1, has become infructuous. The same is dismissed as infructuous.
Yep. 8th January.
Item number 701.
I'm appearing for the award debtor number 2, my lord. He's the one, my lord, in respect of which the arrest warrant was issued by this court by a coordinate bench. He's present, my lord.
Your Lordship, I'm for the award holder.
Sir, I mean, my lord, situation is very bad in the company.
But you have to do something.
I
about
know
it. You
we are
can't take the
working
money
towards
and
it.
say
We
you
are
can't
working
pay.
towards it, and we are going under.
So then I'll send you to jail.
Sir, I mean, if I am not there, I'm the only one because
So make the payment. We are
I
giving,
am, sir.
we are giving you time to settle it.
Yes, and the talks of settlements are already on.
So try to do that, okay?
My lord, I assure you that I'll give the best, very best to get this thing sorted out.
So we'll sit him down, my lord, and we'll impress it upon only one small thing, my lord. We filed an application, nothing to do with the arrest warrant. That's to do with, my lord, the award copy based on which the execution proceeding has been instituted. That has never been served upon me. That's appearing as GA1.
Yes.
It was never served upon us by the arbitrator. I was never a party to the arbitration. But anyway, I'll not trouble your lordship with all of that. When the application comes, my lord, I'll endeavor to move it. If my lord is not with me, I'll bow down to whatever my lord decides.
I'm not with you in execution proceeding.
Very well. I understand. That's the case I have to make out in the section 34.
Absolutely.
I understand, Mullah. That's the
So you
view.
better withdraw that application.
On the next occasion, Lordship. But only one thing, Mullah, there was an earlier direction to file my affidavit of assets. Mullah, I'll ask for some extension of time. We'll file it before the next returnable date.
You file the affidavit in the format.
Your Lordship, already you have given a lots of time, and he didn't file.
We didn't.
That's why he's here now.
An award has been already signed it to him. They are challenging the execution
We are
application.
not concerned.
Okay, as you wish, Your Lordship.
Mr. Award data number 2, Jyotirmay Guha Sarkar is present in terms of the warrant of arrest issued on 25th September 2025. Oath has been administered. He undertakes to file the affidavit of asset within a period of 2 weeks.
I'll have to.
2 weeks.
I'll have to wait it. Not he might be able to produce more. I'll have to sit down. Because I'll be appearing.
2 weeks is enough. Not more than 2 weeks. Affidavit of asset within 2 weeks, and also undertakes to appear before this court for examination or for any other purpose as decided by the court. Warrant of arrest is discharged.
My lord is made it returnable on my lord.
Returnable after 4 weeks. 4 weeks, 15th.
I'm extremely grateful. Sir, my lord has one last indulgence. My lord has recalled the warrant of arrest. Otherwise,
Sorry, warrant?
recalled the
He is discharged.
Great. Extremely grateful.
Sir, I which matter you are sitting?
Municipal matter.
Yes, we are taking it.
I want. I know just we have missed the list today.
Don't say that, Mr. Rai. We are just. I've kept this.
These are all the matters.
Let him start. Let him.
He's a petitionist.
Yes.
I'm for the municipality, and my landed friend.
Correct. So let the petitioner start. Let's not. At least
give us a list. Any matters I'm.
No, I'm just saying that since I have kept only this matter, at least
Yes.
let's utilize some time, Mr. Rai. Otherwise,
Yes. One matter I appear for the state, my lord.
Yeah, I remember you appear for the state.
Affidavits are ready.
Yes.
Now, my lord, in gist, I can tell before your lordship that the petitioners can be classified under 2 groups. Just for the, my lord, the benefit of ours, my lord, the petitioners can be classified under 2 groups. One who were appointed and governed by the, my lord, the act prior to 1993.
All right.
Prior to 1993, the act which stood at point of time, prevailing act, they are governed because their appointment at that point in time before 1993. Other sets of the petitioners, they are governed by 1993 act. Then, my lord's earlier order was that the judgment delivered by our High Court, the division bench, whether that judgment, to what extent it is applicable in the case of the petitioners.
Right.
Now, my lord, he has to satisfy the petitioner first that judgment is applicable either to all or to a class of persons after 1993 or before 1993. So let him be, my lord, be satisfied. Then, my lord, we shall, my lord.
Sure.
But today our difficulty is that, yes, all of a sudden matter appeared. And, my lord, so far.
No, I have mentioned it, but lordship said
No,
the day
but
lordship
without notice.
There was a notice. There was the previous occasion.
No, we are not making any allegation against the lawyer. No,
No, sometimes I feel.
We are not. If my lord can take up the matter.
I shouldn't have taken all this burden on myself.
No. My lord can take up the matter today. Let him, my lord.
No, I'm saying that I made a mistake, because.
Never. No. Never. No. That we cannot say. No, that is not.
My board itself is a very heavy board. And then I've added all this on
But
my.
today is not the Friday. So, we know, my lord.
No, that's why I kept it today. I thought that I'll at least start the.
My lord, kindly start. Now, let him start. We have no. Start. Yes. Matter to almost সবাইকারই জানা আছে।
Well, the writ petitioners before your lordship, the writ petition number 1.
So I hope you have understood what has fallen from.
Yes. Well, as my learned friend, my senior learned friend has said that there is a division bench judgment.
Yes.
My lord, which more or less covers a class of employee.
Yes.
But there is another judgment passed by the honorable division bench.
That more or less cover. You have to satisfy.
Devranjan Bishwas's case, which takes care
So
of.
if you will be candid and you can make, my life easier by saying that, those people who are covered by the judgment and those who are not covered by the judgment. in the matters. Then it will be easier for us to,
May I say this, my lord, all these is in
by
10
saying that everyone is covered, then you make
no.
my life slightly more difficult,
No, may
where I
say
have to do that exercise.
to this, my lord? No, I will be coming up with a list of dates.
So if
And
you'll be
also
fair to the court and
also
do that
classify
exercise and tell me, it will be easier.
also classify which sets of doctors, my lord, are coming under the Bengal Municipal Act and which sets of doctors are coming under West Bengal Municipal Act. My lord, more or less, my lord, the issue is covered in two division bench judgment. One is the present one, where the West Bengal Municipal Act employees are there and they are governed by the division bench judgment presided over by Honorable Justice Rohit Banerjee. Another division bench judgment, my lord, which covers the Bengal Municipal Act doctors, my lord, that is also there. I have annexed in the writ application that covers those doctors who were appointed prior to the date of coming of the Act of 1993. Now, my lord, the issue is the writ petitioner number 1, my lord, so far as he is concerned, he has been appointed under West Bengal Municipal Act by through the resolution of the chairman of the Damdam municipality in the year 1994, my lord, thereafter, and he was appointed and engaged in a substantive capacity. Substantive capacity. I have enclosed the service book, which is at page 48. Lordship, on page 48, Lordship will see I have been engaged in a substantive capacity. Thereafter, my lord, I have been afforded with the regular pay scales and all the pay commission benefits were also advanced and also has been made applicable in my case. Now, thereafter, my lord.
Alright, so show me the initial date of appointment.
Yes, my lord.
What are you agreed with? What are you seeking?
Page 48.
Let's go one by one and just indicate the. Oh. The pleadings are complete, right?
Pleadings are complete.
Pleadings are complete. No, in all the matters, pleadings are complete.
Yes, my lord. Pleadings are complete.
Yes, show me now.
Either by way of affidavit or by way of a report in the form of affidavit. But dealing with the main concern.
Yes, my lord, kindly come to page 44. Page 44 of the writ application.
Yes.
This is the resolution of by which I was appointed by the chairman of the municipality.
This is the appointment.
Yes. This was the appointment. In accordance with the resolution adopted in the meeting of the Board of Councillors held on 31st of August, Dr. Ashok Ranjan Kundu, MBBS, is appointed temporarily to the post of RMO, that is Residential Medical Officer, in the emergency department in Damdam Municipality Specialized Hospital Cancer Research Center. Well, this is the resolution. I was appointed under the West Bengal Municipal Act through a resolution of the chairman. Now, next page, well, let's see, this is the order of confirmation. This is of 18th of August 2000. That this is to inform you that you are confirmed in the post of medical officer in emergency.
You are appointed as the RMO.
RMO.
So 31st August 1998, RMO.
Yes.
All right. Then
my lord, it appears on 18th of August 2000. I was confirmed in my service. My lord, then kindly come to the
18th August 2000.
2000. Then I should kindly come to page 48. This is the service book.
Yes.
In the next page, my lord, will find at page 49. My appointment, the substantive appointment as residential medical officer, where it has also been mentioned that I have joined on 1st of September 1998 with a pay scale which I am entitled to. Now, thereafter, other pages are also there in the service book. My lord will find. Pay fixation is also in terms of in page 52. Lordship will find the pay fixation, refixation is in terms of the government order dated such and such. So all the pay scales which have been accorded to me, my lord, it is as per the government scale. So, my lord, only in 2016, my lord, I made one representation before the appropriate authority.
Page.
Will you kindly come to the no, that is at present is not there, but fact remains is this on similar issue. This honorable court has passed an order which I have also annexed. Similarly placed candidate.
Your representation is dated. Anyway, what happened? What is the outcome of the representation?
The outcome of the representation, they didn't consider it.
Any order?
My prayer was twofold.
Any order they have passed?
No, they have not
rejecting.
passed any order.
Then what happened?
My lord, then my lord, we approached before this honorable high court.
WP
High Court,
writ petition. Which writ petition you have approached? Is it the first one? This is Matt, can't be.
Page 54, my lord, if you kindly come.
Is it WP 5463?
54 or 2016?
2006.
2016, my lord.
That is 4259 of 2016. That the appeal is on page 109. Where is the writ? That's on page 192.
Yeah, my lord, kindly come to
4296, page 192. 4262, sorry.
4262.
Of 2016.
That is at page 84.
192. Here it's 192, sir. Your petition here. I marked it.
192 is the order.
Is the order.
Order of the director of local bodies.
Well, that's the order of the
That is
director.
the impugned order.
Okay, that's the impugned order.
Yes,
Also dated 9/4/2024.
Yes.
Where is the order of the
Yes,
court?
my lord, we approached before this honorable high court. Honorable high court on 84, my lord, page 84. Page 84, my lord, as because already the issue was covered in Debranjan matters case in a division bench. So the writ applications were all disposed of in terms of that order passed in the division bench. By consent of the page 84 is this.
What is the direction?
Direction was that, my lord, to grant post facto approval. And
which page? Show me the direction.
Page 84, my lord.
Page 84.
Page 84. By the consent of the parties, the two applications are taken up for hearing and treating the same as on daily list. Sufficient cause is shown. Both the applications are allowed by recording the date of Lokapal wishes and substituting its Vito Punyo wishes as petition number 3. As the facts are similar, the respondents are directed to act in terms of the judgment and order dated 30th January 2008 in MAT number 704 of 2007. That is that is Chairman Domdom Municipality and others versus Demrajan Vishwas passed by a division bench of this court. I passed an order in terms of prayer A of
So they are supposed to follow MAT 704.
704.
What is
704 is at, my lord, page 56.
54.
56. Yes.
What are the direction in MAT 704?
The directions are at operative portion. Yes. It has been typed also.
Page 64, huh?
Yes. Type page is 83. Since the respondent number 1 had retired from the service and since over 7 years have gone by, we now therefore direct the concerned applicants to immediately and forthwith, but not later than a period of 30 days from the date of receipt of a copy tax, take all steps that are necessary for compliance of the operative effect of the order of the learned single judge. If the same is not done within the period indicated above, the respondent number 1 will then be entitled to an enhancement in the rate of interest from 9% to 10% wherever the same rate has been mentioned by the said learned single judge.
So where's that order of the learned single judge?
Single judgment has already, my lord, that is not annexed, but single judge has already passed an order in my favor, directing them to grant post facto approval and to give me the pension, which was taken in appeal by the state government, and this is a judgment, my lord, which has affirmed the order of the single bench. And since this is a matter relating to post-retrial dues of a person who has retired for more than 7 years, we consider it just and appropriate also to direct the department to issue Xerox certificate of the judgment within 3 days from the date of an application if it is made in favor. So this was the direction, my lord. The direction was there to give the retrial benefits. But this is the judgment that was relied upon by the learned single bench. And in terms of this judgment, my lord, order was...
Show, sir. Don't say it. Show from the documents. Take me to all the documents.
Yes.
Whenever you are making a submission, please show me the corresponding document from where it is coming.
84, my lord, just now I have...
84, 83 you have shown me. You are saying that there is an order of this learned single judge which has to be complied. And you don't have the learned single judge's order on the file.
My lord, I have enclosed the division bench order because the reference was given of MAT 704.
That's your choice, not my choice.
No. My lord, 704, my lord, has affirmed the order of the single bench.
So the order of the single judge is not
Single
here.
judge is not there.
So you should have annexed it.
Justice Sinha's order is not there.
You should have annexed that judgment.
I will. No, Moharaj Sinha's order. Moharaj Sinha order chilo single bench. Now, my lord, thereafter,
I can't keep hearing these matters. I'll release it. I don't have so much time.
my lord, matter is very easy.
No, it is not. You're not making my life easy.
My lord, this is the first day, my lord. Kindly give me...
No, first of all, I can't take out time like this. Please understand, sir. I have my own roster.
No, my lord, kindly come to one...
I have no reason to keep these matters. It's absolutely a burden for me. And if I don't get adequate assistance from you, makes it more difficult for me.
May I say this, my lord? After this order...
You mention it, you will list the matter, and then you're not prepared. It's very difficult for me. Why should I hear these matters?
Well, after this order was passed, my lord, it was taken to the appeal before the Honorable Justice Vishwanath Samadhi. That order also have annexed.
I need proper assistance, sir. This kind of assistance is not helpful for me.
Well, kindly come to page 89 for once.
Just by saying you're covered doesn't help me. You have to show me how.
The order which was passed in 84.
Show me from the file and read the order, sir, please.
I'm reading the
For
order.
God's sake, read the order. Tell me how you are covered. Show me the direction from the court.
Then, my lord,
Don't just make statements like that.
Then Lordship allows me to go through the order passed.
I am allowing you. Am I stopping you?
Then, my lord, I'm reading from page 70. of
Please
Lord
tell
Justice.
me which is the operative portion, how it is applicable on you. Give me the facts.
Then kindly come to
What do you want?
Page 70 of the division bench.
At least you should be prepared to give exactly what the court wants. Tell me.
The appeal is against the judgment and order dated 8th of December 2006, passed by the learned single judge of this court in WP number 5463W of 2006, whereby and whereunder the writ petitioner filed by the petitioner respondent number 1, Debranjan Bishwash, hereafter referred to as the respondent number 1, was disposed of with a direction upon the Dum Municipal Authority to take steps for release of pension in his favor within 2 weeks from the date of communication of the order. A further direction was made to the effect that respondent number 1 would be entitled to receive interest on the arrears of pension with effect from 30th of June 2000 till payment at the rate of 9% per annum. The appellants were also directed to release a sum of rupees 10,600 being the balance of the gratuity amount, together with interest at the rate of 9% thereon, with effect from the date of retirement of the respondent number 1 till payment. Learned counsel for the appellants has principally taken the point that under the provision of Section 54 of the West Bengal Municipal Act 1993, it is only the state government and the state government alone which could have appointed and or approved the appointment of respondent number 1, and since he was appointed by the chairman of the Dum municipality, he is not entitled to pension. He also submits that under the provision of Section 53 of the State Act, the municipality can have, amongst others, a medical officer, but under Section 54, such an officer can only be appointed by the state government and not by an authority of the municipality. And Section 53 and Section 54 of the West Bengal Municipal Act 1993 read as under. Section 53 of the Municipal Establishment, save as otherwise provided in this Act, a municipality may have the following officers: an executive officer, a health officer, an engineer, a finance officer, a medical officer, a secretary, and office superintendent. One or more of the sub-assistant engineers.
So basically, the state government is saying that since you're not appointed by them, you're appointed by the municipality, you're not covered.
Yes.
Now, how does the judgment deal with that? Let's go.
What my submission is this: that power was there after 2002 amendment came in the West Bengal Municipal Act. But prior to that, the power of appointment to the extent of 1% of the total sanction rate was there with the concerned municipality, and municipality can create a post and can give appointment if it is within the 1% of the total sanction. That was the provision which was there prior to 2000. After 2002, each and every appointment has to be made, and there has to be a prior sanction from the state government. Then one or more of the sub-assistant engineers, one or more of the site inspector, a head clerk, a head assistant, an accountant, a surveyor, and draftsman, such other officers as may be designated by the state government in this sphere, provided that the state government reduce the number of posts of the officers as aforesaid for any municipality. Provided further that the state government may by order undersigned may all the posts aforesaid in respect of any municipality. Subject to the provision of subsection 1 of this section, the Board of Councillors may at a meeting determine which of the officers referred to in subsection 1 of this section are necessary for municipality, and with prior sanction of the state government create posts of such officers and fix the salaries and allowances to be paid and granted to such officers. The Board of Councillors at a meeting may, subject to the norms regulating the size of the municipal establishment for each municipality and the categories or designation of officers and other employees of each municipality with their scales of pay as may be fixed by the state government from time to time, determine what officers and other employees other than the officers mentioned in subsection 1 are necessary for the municipality, create posts of such officers and other employees, and fix the salaries and allowances to be paid and granted to such officers and other employees. Subject to the norms regulating the size of the municipal establishment as may be fixed by the state government under subsection 3, no post of an officer or other employee shall be created under subsection 3 of the Board of Councillors of a municipality may, with prior sanction of the state government, create, if it considers necessary, so to do, for due discharge of municipal function, a post of an officer or other employee which is not included in the mode as may be fixed by the state government under subsection 3, and fix salaries and allowances to be paid and granted to such officer or other employees. Until the norms are fixed under subsection 3, no post of an officer or other employee shall be created by the Board of Councillors of any municipality without the prior sanction of the state government. Cadre of common municipal service appointment, etc. The state government may constitute a cadre of the state in respect of executive
officer, health officers, engineers, and finance officers referred to in subsection 1 of section 53. The state government shall be the appointing authority of all other officers burnt in the address committed under subsection 1 and shall be the authority to transfer such officers from one municipal area to another. Provided that until the cadre is constituted under subsection 1, the Board of Councillors may, with prior approval of the state government, engage officers to the post of the health officer and engineer, sanctioned by the state government on contract basis or otherwise, and the qualification and the recruitment procedure for such engagement shall be such as may be prescribed. Provided further that the remuneration for such engagement shall be paid from the municipal fund. The appointment of all other officers and employees not included in subsection 1 shall be made by the municipality with the prior approval of the state government. The recruitment to the post of officers and other employees not required to be made through the Municipal Service Commission constituted under subsection 1 of section 55 shall be made through the local employment exchange or through such other method as the state government may determine.
All right. So prior to appointment before 1993, the 32 rules were applicable. The
Bengal Municipal Act was there.
Under that, the commissioner had the power to appoint the officer. So there's no dispute as far as
it's an admitted position.
Any appointment prior to 1993 is concerned, right? Subsequent to
93 Act, there is a provisions. 32 Act, there is a provisions. And I just asked the court what happened, my lord. Is that we have the hospitals. When those doctors are appointed and confirmed. And on the verge of retirement, but they're entitled to get the pension benefits or not, this is the issue. Now, controlling body is the director of local bodies. He's the controlling. The earlier matter, the several retribution was fine. Ultimately, it was decided by Justice Bhattacharya that they are entitled to get the benefits. Against the order, state government preferred the appeal. In the appeal, the issue was raised by the Senior Council that since it is the sanctioned post, the government does not have any income to
sanction post, and the government has not appointed them. They were not appointed.
Then I have come to rescue him. I have come to rescue him. I have given the I have shown the act. The act says in 53 this 93 Act before
amendment section 66.
Yes, 53.
sorry.
Before amendment,
section
Bengal
63. 66.
66. 32 Act. This is 92. Both the acts.
32 Act 66, section 66. That's cover them. So appointment of medical officer regularized.
So the law says, my lord. So these are sanctioned posts 100. Only one post municipal can do it.
Only one post?
1%.
1% I can municipal can appoint without sanction of the state government. So we have given the chart. In other cases, there's 324 sanctioned posts 1 year. So we have appointed 3%. In this way, most of the petitioners they have been allowed.
Regularized.
So I have made a chart. Now is another bunch. Yes, brought it.
That chart is there in this honorable.
I'll show people lordship. I made a chart. I'll show them whether they're coming. The year is very
crucial.
Crucial, and how many posts are filled up on that year. This is very crucial. So I have to give a chart, your lordship. Then when I made it, I might give it in a proper form. So whether they're coming on 32 acts or under the 93 acts before amendment. 93 acts also the provision, subsequently was amended, this provision was repealed. So before that they got the appointment. So 2 and 4 cases, there's some difficulties is that in 1 year, 3 or 4, 2 and 3% appointed, but sanction post is less than those numbers. So I give this is the issue, whether there's an appointment was made, they were confirmed, they got the benefit of the salary, and now the pensionary benefits, whether state government will take the responsibility or not, is the issue.
So you would have filed your reply. You
also I need to file a reply.
have not filed.
Yes,
Ms. Bowell, you have
exchange man.
Yes.
Pleading
it has been filed.
So I'll make a chart. That will be better for me. I give my notes. Notes. I know the losses. I give the notes of list of
That
tests.
helps, Mr.
No, I know you.
Lordship, kindly appreciate one thing, my lord. All the petitioners, my lord, their names were recommended for sanction before the director of local bodies, including the petitioners here. And that will be appearing at page 170. Kindly see. Okay, kindly come to, yes, page 120. The internal page 12 of the division bench order.
These are given the chart.
This is a chart which was given in the form of an affidavit.
Yes, that is.
And it has been reproduced as it is.
That
So kindly
I
see
have
on
come to what you
appearing for the municipality, Mr. Omalesh Rai, learned advocate, drew our attention to certain paragraphs of the municipality's affidavit affirmed on January 6, 2023. It would be helpful to set out a few paragraphs from the said affidavit. On a scrutiny of the said chart, it appears that there were 341 sanctioned posts in Domdom municipality as on 1st of July 1998. Out of 341 sanctioned posts, 7 sanctioned posts were filled up by the officers referred to in subsection 1 of section 53 of the said Act 1993. I say that the names of the residential medical officers, medical officer, dental surgeon, resident physicians have been sent to the office of the director of local bodies in connection with the instant case, which are as follows. Well, kindly see the present petitioner name is appearing at serial number 7. Next page. And all the petitioners before your lordship, their name are appearing here. So it is, it can be said, my lord, that they are all be unappointed within 1% of the total sanction state of the municipality.
All right, makes sense.
But unfortunately, my lord, they were not provided with the relief. Because here, what the state governments are saying, that as because there is no sanction from our end, we are not recognizing your service. For that reason, my lord, we have to demonstrate before this court that state.
No, but then they will be covered in a different proposition to the extent that the state government need not regularize their service. They were falling in that 1%
Yes, yes.
of
Automatic sanction.
automatic sanction.
These are the sanction posts. It is not required to get the sanction post from the
Correct.
state government.
They get the benefit of section 53 of the
That has
1993
been
Act.
noted in page 17, 117. Lordship, kindly come to page 117, 117. Paragraph 18, last paragraph. The alternative argument of learned counsel was that section 53, subsection 3 and subsection 4 of the West Bengal Municipal Act 1993 as they stood prior to the amendment of subsection 4 by the West Bengal Act of 16 of 2002, which came effect from 2nd of September 2002, permitted the board of councillors of a municipality to create the post of an officer or other employee without prior sanction of the state government, if the number of posts to be so created in a year was not more than 1% of the total number of sanctioned posts of officers and other employees in existence in the immediately preceding year. It would be helpful to extract subsection 3 and 4 of section 53 of the 1993 Act as they read prior to the 2002 amendment. The board of councillors at a meeting may, subject to the norms regulating the size of the municipal establishment for each municipality and the categories or designations of officers and other employees of each municipality, with the scales of pay as may be fixed by the state government from time to time, determine what officers and other employees other than the officers mentioned in subsection 1 are necessary for municipality, create posts of such officers and other employees, and fix the salaries and allowances to be paid and granted to such officers and other employees. Subject 4. Subject to the norms regulating the size of the municipal establishment as may be fixed by the state government under subsection 3, no post of an officer or other employee shall be created under subsection 3 of the Board of Councillors of the municipality without prior sanction of the state government if the number of the posts to be so created in a year for municipality is more than 1% of the total number of sanctioned posts of officers and other employees in existence in the year immediately preceding. Mr. Roy submitted that it would appear from the affidavit affirmed on January 6, 2023 on behalf of the Domdom municipality that there were 341 sanctioned posts in Domdom municipality as on 1/7/1998. Out of such posts, 7 posts were filled up by the officers referred to in subsection 1 of Section 53 of the 1993 Act. In the year 1998, only 3 persons were appointed by the Board of Councillors of the municipality, which was less than 1% of 341. Hence, prior sanction of the state government was not required for appointing the writ petitioner. Consequently, his retail benefits cannot be withheld. Mr. Roy relied on the decision of a learned single judge of the court in the case of Ranaghat Municipal Employees Association and others, was the state of West Bengal and others, reported at 2003 volume 4 CHN 55, and in particular on paragraph 5 thereof, wherein the learned judge obscured that section 53(4) of the 1993 Act permitted a municipality to create a limited number of posts without the sanction of the government. Learned Counsel also relied on the decision of the coordinate bench of this court in the case of the state of West Bengal and others versus Tapos Chakraborty and others, reported at 2019 volume 1 CHN 684. It may not be necessary to discuss the said judgment for the purpose of deciding the present appeal. Now, my lord, these are all the charts which have been provided, including the name of the petitioners are there. And thereafter, my lord, from page 121, precisely it has been stated that your writ petitioner is coming within 1%. Page 121, paragraph 7b.
Yes, I've seen that.
I say that the names of the residential medical officers of Dom.
So you appear for the municipality.
Minister.
You're supporting.
I
The
said
savior.
Yes,
I-
they
I
have
will-
already filed
I
a
will
reply.
excuse them.
And before the division bench, my lord, upon including these names and upon filing this affidavit, the honorable division bench was pleased to direct the state government whether they have any objection to that or not. But state government didn't prefer any objection to the name which are appearing here. Now 7b, I say that the names of the residential medical officers of Dom Municipal Specialized Hospital and Cancer Research Center.
They're all covered according to the chart.
Yes, but
Yes.
no, I've seen that there are 2 and 3 matters. These year, 3 persons are
No,
appointed.
in this one.
But they were within the norms.
Here,
They were within the norms.
So you give me a.
Yes,
Mister.
This matter.
Don't get excited.
I am
Anybody-
recollecting, my lord.
Don't-
I have forgotten
Yes, yes.
somewhere.
I'm not injected in this. My lord, this matter is allowed.
This one is allowed. Absolutely.
Sometimes I list of the matters, I think 1 and 2 matters, sometimes because
So just show me, Mr.
I'll give a chart one.
All right.
And Monday I'll give the chart and I will everything I'll give. That will be better. And list of dates, notes of argument, and my lord. That will be better for
And
all the matters we covered by your law.
a director of local bodies.
You also do that exercise.
Well, I will, my lord. There are several.
He will not do,
litigations, my
I'll
lord.
do, I know it.
My
I'll
lord,
do.
kindly appreciate. I'm
Sit
aware.
with him, sit with Ms. Boval and help him prepare a chart.
My lord, only one thing, my lord, director of local.
And use Mr. Roy. His time is precious.
Even I'll do. Even my junior is very competent. She's very competent.
Yes, I've seen her.
She's very competent.
My lord,
I
thing
used to
is this.
stay there. She's maintaining here, looking after here.
Yeah, she used to regularly appear in the municipality side.
My lord, before this is the judgment, my lord, which covers so far as the West Bengal Municipal Act employees are concerned. And the judgment which I was reading and was assessing your lordship, that was of Debranjan Vishwas's case, where the Bengal Municipal Act was considered. So in both these scenarios, my lord, the issue is well covered. So state government every time and then they again reopen.
So according to you, sir, this one is covered. Now tell me which one is not covered.
Not, my lord.
Or where you think there is some issue.
I've just
Yes.
checked the 1 and 2
So
cases.
far as my lord Rafiqul Hassan's case is concerned.
Wait. So Asit Kumar Kundu is okay.
Asit Kumar Kundu, Shoktilal Chaudhary,
Ekটু লিস্টটা দাও।
Dr. Priyadarshini Sarkar.
Sir, which just a minute. Asit and
Only these 3 persons, my lord.
which one you said? Other one?
My lord, Priyadarshini Sarkar. Dr. Priyadarshini Sarkar.
Yes. Priyadarshini Sarkar
And Shoktilal Chaudhary.
My lord, item number 2, that is Rafiqul Hassan. He is
Yes.
coming under Bengal Municipal Act. Then my lord Bidhan Chandra Mondol. He is also coming under Bengal Municipal Act. Then my lord Purnima Biswas. He is also coming under Bengal Municipal Act. Thereafter, Omlan Kanti Mojumdar, my lord, he is coming under West Bengal Municipal Act.
There's no problem with that.
No, it's covered. So far as Shukhendu Bhomik is concerned, that is item number 6.
Nima, Omlan, or
Shukhendu, yes.
The three cases, there's some problem.
Shukhendu Bhomik is West Bengal Municipal Act.
So it's covered.
Not
Yes.
only that,
Thereafter, Priyodarshi Sarkar, that is 7. Priyodarshi Sarkar is also West Bengal
Covered.
Municipal
That
Act.
he said that.
Thereafter, my lord, Shubhajit Bhattacharya
Yes.
is also West Bengal Municipal Act.
Not covered. Is it?
Thereafter, my lord, Dr. Amitesh Sarkar, Bengal Municipal Act. And 10 Chandana Ghoshal, he is also Bengal Municipal Act. In Bengal Municipal Act employees, my lord, they are covered under Devranjan Bishwas's case.
So give me a chart
issue
of cases covered under Devranjan Bishwas case, which is under the Bengal Municipal Act and West Bengal Municipal Act. And please, Mr. Rai.
And also, my lord, to some extent,
You know what I want.
Yes, I know.
and also to some extent, my lord, your lordship has already passed a similar order. I will be relying upon that also, which covers the issue at hand, because here also the employees were casual employees. They were subsequently absorbed, but again they were deprived of their retirement dues. Now state government made a plea here that they were all posted in they were appointed in unsanctioned post, not sanctioned one. So lordship has asked that the state government to create a supernumerary post.
We'll keep it. Monday we'll keep it.
Yes.
Gopal.
Monday.
No, Monday no. My lord,
क्या मंडे कुछ रखा है
my
सेकंड
lord, my lord,
केएमसी रखा है
my lord, can it be?
yes
Monday,
किस दिन
No,
खाली
Monday week.
No,
My lord,
Monday.
can it be, my lord, any day convenient to your lordship,
let me
7 except Monday, my lord.
Monday is not gonna happen.
My lord,
Let me see.
Lordship is directed to create a supernumerary post and to at least accord pensions.
That's a different thing.
No, 2 and 3 cases, maybe then we try to apply this. Then make it
गोपाल डेट बताओ किस दिन रख सकते 10th को 2 बजे 10th क्या है 10th at 2 p.m.
Yes.
Yes, calendar.
Next Wednesday.
नंबर ना 10th को है
That 10 2 p.m.
हाँ तो इसको 2 बजे रख लेते हैं ना
बुधवार.
हाँ 10th at 2 p.m. 10th at 2
No, I extend them my.
because this will not take much time.
You know, I know take much. I'll extend them my notes.
Please do that.
And my lord, in the division bench matter, my lord, our senior advocate general, my lord, Mr. Amol Sen appeared.
Yes,
He appeared.
Motion that
He appeared, and my lord, order was
His junior is here. He's
yes.
he was
Order,
here. He
order,
was here.
order
I
was
know.
order was passed, my lord. It was again taken for review. The review was dismissed, and only thereafter, upon contempt application, they have given us the retirement benefits.
All right.
Again, they are reopening the same thing.
Yes, I'll make the chart one.
10th 2 p.m.
Extend them.
10th 2 p.m.
Let's finish it on 10th, but
Yes, sir. I'll do by you.
there's nothing much in this. We'll finish it on 10th. Heard, learned counsel for the parties. Let this matter be listed for further hearing on 10th at 2 p.m. Mr. Rai, please be here so that.
This is in respect of one or সমস্ত মামলায়
So, Mr. Rai, we are going to have that inauguration
এটা 9
soon.
স্টেটের হয়ে আছে.
July, June, January.
Hopefully soon.
Yes. Then, my lord, I have to stay here all month. Very popular for me.
Not necessary.
No, the timing is very good. It's very good plan.
Lordship is going to call all the matters serially, Lordship. Lordship is going to call all the matter, my lord. Oh, all the serially, my lord. I am appearing for item number 6, my lord.
Which item number?
Is one of the matters.
In one. No, madam, we
Item
are
number
keep.
6, my lord.
No, madam, we are keeping all these matters on 10th at 2 p.m. All right.
Deeply obliged, madam. Let my appearance be recorded, my lord.
All right. ये सौरभ सौरभ item 6 में इनका appearance डाल देना मैडम का.
Deeply obliged, my lord.
3 and 4 बोल रहे ना? You are appearing in which item number 6, right?
6, my lord. 6, my lord. Due to
जो-
my ill health, I could not attend physically, my lord.
For the state कर देना.
Yes.
For the state, my
আমি 9 এ স্টেটের হয়ে আছি 9ও দিয়েছি স্টেটের হয়ে 9ও দিয়েছি স্টেটের হয়ে ঠিক আছে
Mr. Lakhwani, you are sitting for which matter?
Item number 2, execution.
We had kept the appellate side matters today.
I believe from 3 p.m. The list says from 3 p.m. and Lordship will call the original side.
Generally it is, but we had kept this special
Difficulty,
matter.
any other day. Execution.
They are not. I don't see the stuff.
No difficulty, my lord.
Next Thursday.
No difficulty.
No stuff.
No difficulty. Great.
It will be in the list.
If you can just retain its position, it's item 2, my lord. That's great. Great.
We could have taken it, but we don't have.
No, my lord. This has happened, my lord. This is the original side actually, my lord, has now shrunk a lot with DRT and all these the tribunalization that has taken place.
But still, your 34s are.
It's mainly arbitration related work, my lord. Hardly 250, 300 suits a year.
That's true. That's true. That way it has shrunk. But even the awards are like.
But my lord, personally, even my chamber senior, Mr. Abrojit Mitra, very anti-tribunalization as a person. And my lord, we travel often, my lord, we are seeing the difference, my lord. It would have been better had things been retained by a lordship.
The High Court.
At least the operation mismanagement cases, the company jurisdiction, if not insolvent.
Even if you see now 34, the scope is.
Hardly, my lord. It's almost unchallengeable.
Earlier public policy was stretched, but now even the public policy has been
shrunk. Yes.
Shrunk. So literally, probably we are giving impetus to.
No, my lord, I was briefed in one matter where the award was passed before my birth, and it's not an exaggeration actually. 1989 or 1990 award, my lord, I was doing the matter. I was born in 91. But, my lord,
the larger intention, my lord, is to reduce the interference of courts.
No, now with Perkins.
That's the whole idea.
Now with Perkins, my lord, and unilateral appointments no longer there, my lord, this is it's a feasible thing. Even an error of law is not adequate. Mere error of law not adequate. Is your lordship rising, my lord? Very. I'm sorry, my lord. You're one. Hey, wait.
But I appear for the award later.
Yes, my lord.
We were served with a substitution application. My learned friend will begin, my lord, because possibly there has been an assignment of the loan from ECL Finance to Kotak Mahindra Bank, but no order has been passed with respect to substitution. We have just been served with that application.
There, it has been allowed.
Substitution has been allowed.
My lord, I've been then instructed wrongly, my lord, then the substitution.
What is the order?
We have not appeared, my lord. I've been recently engaged. So then, my lord, the application can proceed, my lord.
Lordship, let them file the affidavit of
Affidavit of
We have
asset.
to file the affidavit of asset.
Learned counsel for the award debtor seeks and is granted 2 weeks time to file his affidavit of asset. Let this matter be listed after 4 weeks. Full stop.
But may a copy of the substitution petition be served upon us?
Just give a copy of it.
Lordship will serve.
But that was not served, which is why I was under the wrong instruction.
We serve, but
Akbar, correct
it
you.
was
Take
not.
this.
Is your name?
Grateful.
No, this is my application for execution of an arbitral award. This is an award passed in favor of, my lord, a victimized flat purchaser.
2 years, beyond 2 years.
Again, no, my lord, within 2 years, my lord. The award is of May 2025. If your lordship will, my lord, consider only page 62 and 61. 61, my lord, your lordship will see. The award, my lord, is of 75 lakhs plus interest 12% from 24th November 2021 until the date of the award, that is 6th May 2025. So the interest until the date of the award, my lord, the entire amount comes to 1 crore 6 lakhs 9,315. And my lord, further interest on award 12%. That as on 30th November, calculations are up to date of filing. But as on 30th November, my lord, it is 1 crore 13 lakhs 28,941. And additionally, I've been given costs of 6 lakhs 82,000. So it's about 1 crore 20 lakhs as of, my lord, today, with interest and costs. My lord, the developer against whom the award has been passed, my lord, is, my lord, a habitual defaulter. It's, my lord, a matter of record that, my lord, ED has been also, my lord, inquiring into their affairs. High Court is flooded, my lord, with litigation against this particular developer. It's the Vedic group. My lord, they have these. Yes, your lordship would have, my lord, I'm sure, seen other matters. So, my lord, there is a chance, my lord, that they may dissipate the assets, my lord, they may flee. They are not, my lord, they have a notorious record. So, my lord, I'm praying if lordship may consider, my lord, of course, for the directors to be present, for the affidavit of assets to be filed. And, my lord, at page 62 are the assets which I know of that they have. My lord, if, my lord, orders could be passed to secure, my lord, 1 crore 20 lakhs. It's a crystallized award, my lord. What had happened, my lord, I'll tell your lordship. It was actually a, my lord, award, a claim for specific performance of an agreement for sale, where I was to be given a villa. And they'd taken advance money. In their statement of defense, they disclosed that the villa has been alienated to third parties. And they took a plea that since third party interests have been created, matters not arbitrable, because in the absence of third parties, you can't arbitrate and they are not parties to the arbitration agreement. We had to amend our claim to make it a claim, my lord, for refund of money and damages, and my lord, that's how the award ultimately has been passed. So my specific performance prayer was, my lord, it could not be, my lord, carried forward because they'd already sold the villa to somebody else. And they disclosed this in the arbitration, and they took that as a point of maintainability of the arbitration.
And they have been making payments, there are more petitions here, execution.
Lord, if I can be candid, my lord, How much they pay, my lord, keeps changing with the roster. Every 6 to 7 months, my lord, the rate at which they, my lord, pay and settle, my lord, changes. And there is no 34 file, my lord. To the best of our knowledge, my lord, more than 120 days are over. Neither has a 34 been filed, nor can it be filed because now, my lord, Section 5 will not, Limitation Act will not apply, my lord, to the Arbitration Act.
Learned counsel for the petitioner has preferred the present petition, seeking execution of the award dated
Award dated
26th February,
6th May
6th May
2025.
6th May 2025. Full stop. It is the case of the petitioner that he had entered into an agreement for sale on 24th September 2013 for purchase of a golf villa. Full stop. Counsel for the petitioner states that the said agreement was breached and they had initiated the arbitration proceedings. Full stop. In furtherance of the same, the arbitrator, by award dated 6th May, so and so, awarded an amount of rupees
75 lakhs. Kindly take the last paragraph at page 59. Just the last paragraph, it's summarized there.
Awarded amount of rupees 75 lakhs in favor of the claimant with simple interest on the said sum at the rate of 12% per annum from November 24, 2021 till the date of the award. Full stop. It was further noted that if the claimant it was further noted that the petitioner will be entitled to interest on the award at the rate of 12% per annum from the date of the award till the date of payment. Full stop. A cost of rupees 6,82,000 was also awarded. Full stop. Learned counsel for the petitioner states that till date no section 34
to the best of our knowledge.
To the best of his knowledge, no section 34 petition have been filed challenging the award. Full stop. He states that he will suffer irreparable loss if the assets of the let's get the affidavit filed first, then we'll see about the assets on the next date.
Let
the
it
first
be,
date.
Because I'll tell you, Lordship, this is a group of companies and my award is against a specific entity.
That's
now,
right.
if the money goes from this entity and my lord goes into some sister concern, it will be an uphill task for me, my lord, to execute this award.
So, but
because
how do you know that this property which you have put is of this entity?
This is
best to your knowledge. You can't be sure of
this is my lord based on master data shows all this. No,
you can't be sure about this.
Master data, my lord, just no, my lord, from these bank accounts that are there, insofar as the bank accounts are concerned,
bank accounts I don't want to attach.
We have received some money from these bank
accounts I don't want to. Anybody, business. You don't want to stop anybody's business for bad.
No, my lord, let them just keep aside a sum. My lord, let them. The money is payable to us, my lord. At least
which account you want? How do you know what is the amount? Which account do you want to be?
My lord, if your lordship can consider, my lord, passing an order that in all the bank accounts, what they must ensure that 1 crore 20 lakh rupees is kept aside. Now, my lord, that order will serve upon the banks whom we know, and they'll ensure that this is done. Because, my lord, if your lordship gives an order in respect to one bank account, that may only have 2 lakh rupees, for example. My lord, we will not know how much money which bank account will have. So for the time being, if your lordship can only, my lord, give a general direction, we'll serve that order upon the banks and they'll intersay, my lord, coordinate and see to it.
Irreparable loss if the bank account of the award debtor is not attached. A list of the schedule F. No, this is schedule. The schedule.
Yes, and annexure F.
Annexure F has provided a schedule of the bank accounts of the respondent award debtors.
My lord, may I just say this? I understand what is flowing from my lordship. My lord, your lordship may injunct them from, my lord, operating the bank account without keeping apart that sum.
That's what I intend doing.
Very well.
So just see.
Yes, my lord.
Full stop. Award debtor. Full stop. This code directs that the accounts mentioned in the schedule shall be attached to the extent of rupees.
My lord, its approximate interest is, my lord, accumulating each day approximately 1 crore 20 lakhs. It's a little more than that, but I'm giving a conservative estimate.
Attached to the extent of rupees 1 crore 20 lakhs, which shall be kept separate in the said account. Full stop. It is clarified that the account is only attached to the tune of rupees 1 crore 20 lakhs. The respondent award debtor shall be entitled to operate the account.
My lord, there are 3 accounts mentioned, my lord.
All the other accounts. I'll just put all the 3 accounts.
Yes, my lord.
Cumulatively,
my lord.
All right. So, तीनों account
Plural.
On page 62. A total of this sum of amount of money shall be kept aside. Apart from that, the respondent debtor shall be allowed to operate the all the other accounts, all the accounts mentioned in here. I think this will be okay.
Yes, my lord.
Further, affidavit of asset shall be filed by the award debtor number.
My lord, there is only one award debtor.
Award debtor.
It's a company.
Within a period of 2 weeks. Copy of this order shall be communicated to the award debtor. List after 6 weeks, after 4 weeks. 4 weeks after 4 weeks.
4 weeks, my lord.
4 weeks.
Whenever. 8, 8.
इसको ऐसे कर लेना, a list of bank accounts have been indicated in the schedule, which are as follows. Full stop. The managers, that is a difficulty, Mr. Lakmani, that how do we ensure?
Lord, your lordship will direct me to serve the banks. I will serve the banks. They are not parties to the proceeding, but I can always intimate. I can always intimate them.
Let it be on the next date. The difficulty is that will create a problem.
My lord, may I just say this? Injunction, my lord, is an order against the judgment debtor, the award debtor. So they will not do it themselves. If we intimate this to the bank that they have been restrained from doing it, the bank will also not allow them to do it.
The problem is, understand what I'm saying?
Yes, my lord.
If I am passing this order,
yes, my lord,
I'm not indicating a figure to the bank. A cumulative of this figure, 1 crore 20 lakhs, which bank will freeze it to what extent, the amount, is a difficulty here. That is a difficulty which I'm facing in passing this order.
I understand, my lord.
That is the only reason I don't want to pass this order. The cumulative figure is there, 120, but what amount to each and every bank is a problem. Let them file their affidavit, we'll pass this order. Let them file their affidavit of asset, we'll pass the order. वो हटा दो, नहीं detail देने के इसमें वो हटा दो, बैंक वाला हटा दो. Let them file their affidavit of asset.
Then would your lordship be pleased to keep this, my lord, at a shorter date?
I'll keep it at a shorter date, after 2 weeks, 3 weeks.
2 weeks.
Let them file the affidavit of asset in 2 weeks. We'll keep it after 3 weeks.
Very well. Chuti again.
If you would have indicated the amount, I would have still done it. 4 bank accounts, different amounts.
Then would your lordship, my lord, just say that they will not alienate assets to the tune of 1 crore 20 lakhs. They have immovable properties. It's a real estate company.
We'll do it next.
Very well.
Let them file it. We'll do it.
Very
They can't run away. They are not able to run away. 3 weeks for vacation. Right after vacation.
Very.
Yes.
Grateful, my lord. Ramdeva. My application for execution. The award was made on my lord 30th August 2011, my lord. And my lord,
beyond 2 years, what were you doing?
My lord, I served copy, my lord, long ago, my lord. They filed opposition, I filed reply. And my lord, Mr. Paritosh Sinha, my lord, is on advocate on record for.
Oh, it's already going on.
My lord, the section 34 application was pending, my lord, and that is why matter was adjourned, sine die once. And my lord, that section 34 application has been dismissed, my lord, on 5th August 2025, my lord. My lord, when this execution application was filed in 2012, my lord, I have given the particulars. My lord, may kindly see my particulars, my lord, at page 6, lordship, of my execution application, my lord. Lordship will find that the principal amount is 90 lakhs 13,100, and my lord, interest is shown there, my lord, 75 lakhs 49,000 and odd, and total was, my lord, 1 crore 65 lakhs 62,000 and odd, my lord. My lord, miss comes once see, my lord, the award, lordship.
Page,
lordship, 23, relevant parties, my lord, 23. My lord, may see that total figure is, my lord, 90 lakhs 13,100. Thereafter, my lord, interest is shown, my lord, since when it was being charged, my lord, and my lord, page para 55, my lord. My lord, coming next to the question of cost on various accounts, I allow cost to the claimant amounting rupees 6,71,000. I'm not reading other part, my lord. Therefore, page para 56, lordship. My lord, why I am placing, my lord, that thus the claim of the claimant for cost is allowed to the extent of 6,71,675, and I have a make a award for cost of arbitration in favor of the claimant for such amount, and I direct respondent to pay the same to the claimant within a period not exceeding 6 months from the date of making and signing of the award. Therefore, my lord, in the in my execution application, my lord,
they will have it on the 18th.
My lord, I have not claimed, my lord, I have not added, my lord, this cost, because for 6 months, my lord, it was not executable, that cost part, my lord. So may I pray before your lordship, my lord, to amend, my lord, the execution petition, and my lord, the tabular statement, because, my lord, interest will be, my lord, added, because since 2012 and we are in 2025, my lord.
The award itself take care of the interest. You don't have to amend it for that purpose.
Lord, if your lordship so many desired, then, my lord, so far cost is concerned, my lord, if it is to be added, my lord, I can, my lord, lordship may kindly permit me to amend, my lord, the.
No need to amend it. Why should you amend it?
My lord, they appeared, my lord, filed opposition, we filed reply, my lord, and but now, my lord, if your lordship permit me to place, my lord, is calculation, lord, as on date,
Keep
my
it
lord.
next week. He's not here. Let Mr. Sinha appear next week. Not today.
Let it appear in the supplementary list, my lord.
Not supplementary. Not every Thursday we are getting these matters.
Lordship, grateful, lordship.
Okay. Daily risk monthly risk कुछ लेना है क्या? I don't.
I'm appealing for the award holder now. They may file the period of service. Period of service. Number one, the award is a money award against Baman Lorry, now a Government of India Enterprise Lord. They are not making payment of that. But may I tell you, Lordship, that there is a little bit history of the matter. Originally, my Lord, there was some construction work executed Haryana. Now, since Baman Lorry's office is here, they issued the work order from here. Everything was signed here. Payments were made from here, part-to-part payments, as per the construction works. Now, after the completion of the work, they did not make us the final payments. So, my client filed a suit before the original site, High Court, Calcutta.
High Court?
High Court, Calcutta, here. Because the other side is here, defendant is here, their office, everything is here. Now, when the suit was, the summons for the suit was served on them, they appeared here, filed a Section 8 application. The point was taken that there is no formal agreement containing the arbitration agreement. But Justice Shoji Banerjee asked both of us to agree to by filing a supplementary affidavit for referring the matter to arbitration. We agreed. And they gave certain names. Out of the name, my lord has appointed one of the arbitrators. They gave, not my clients. Anyway, the arbitrator was a retired engineer, very eminent engineer. He held sittings. Award was passed. The award was, no copy of the award, Section 34 has been served on us. But they already told us that they have filed an application before Barashat Court, which court doesn't have any jurisdiction. There's no part of cause of action under Ryzen, nor my client resides there. So naturally, we filed an application containing that this court, learned court, has no jurisdiction, so this may be released, and direction was given to us to serve the copy of 34. That application was rejected. We came up before this Honorable High Court, challenging that order. We succeeded here. And thereafter, they have communicated nothing, whether they have preferred any appeal against that order before the Supreme Court or not, we do not know. So nothing was communicated. Waiting for some time, we have ultimately filed this execution application in 2023 before this Honorable Court, and copy has been served on them, and they have not communicated anything to us in spite of receipt of this. An item has been delivered. Now, the original principal amount is not very high, 19-20 lakhs. But now with the add of this interest for this long 14-15 years, it has come up to, then when it was filed up to 31st of March, it was 92,26,521. But they are not making any payment, but I have given in my tabular statement also the bank account, that is Standard Chartered Bank, Netaji Subhash Road, Kolkata, 701. For attachment of the
They have filed their reply and all?
Nothing at all, no communications to me. Even 34 petition has as yet not been served on my client.
It's a 2023
application.
Why it has been pending? No orders have been passed.
But it was not.
Only last order is settlement talks are going on.
This is SN engineering. This is
settlement talks.
So far, my knowledge goes, nothing has been settled.
All right, take down. The petitioner has preferred the present execution petition seeking execution of the award dated. This award is of 5/7/2011, right?
5, Lordship Lord.
Award dated 5/7/2011.
15th of May 2012.
15th of May
2012.
15th of May 2012. Full stop.
It is the case of the petitioner that he had been awarded an amount of rupees 19,51,215 with 12% interest per annum from the date of claim till the date of award. From the statement of claim till the date of award, full stop. It was further noted that in default of making the payment of the awarded sum and interest awarded sum latest by 31st July 2012, awarded sum that in default of the payment of the awarded sum latest by 31st July 2012, comma, an interest at the rate of 15% per annum on the award will be paid till the date of realization. An award of 15% from the date of award, i.e. May 16, 2012 till realization. Further, the cost of rupees 3 lakhs was awarded to the award holder. Let an affidavit. There is no direction for affidavit of asset also.
Nothing. But they are government of India companies.
So what, you have to serve them, sir?
Yes, but I've served them. The affidavit of service have filed, the items are delivered on them. That
affidavit of service has been filed. This was when? When did you serve them?
Naturally, immediate.
24th of June. Despite service, none appears for the respondent. The respondents are directed to file their affidavit of asset. Full stop. Within a period of 2 weeks, the respondent directed to file the affidavit of asset within a period of 2 weeks. Let a copy of this order be sent across to the award debtor. Learned counsel for the award holder shall communicate a server copy of the order upon the award debtor for necessary compliance.
And you make it advocate on record. My advocate will communicate it.
Advocate on record
will communicate this.
Shall communicate. Counsel advocate on record shall communicate. List this matter after 4 weeks.
The 4 weeks intervene after vacation.
January, yes.
But would you be lordship pleasure to attach the amount that's lying with the bank?
It's a government company, you'll get them.
Lord, this is my execution application, Lord. This is award of Lord, Lord, in 2008. And Lord, Section 34 application was filed, Lord, and award was partly modified by Honorable Justice Sabyasachi Bhattacharya, Lord, in July 2025, Lord. And thereafter, this execution application is filed, Lord. And Mr. Paritosh Sinha is here also, Lord, for state, Lord.
Not this week, next week.
Yes.
Next. '81. None for the parties. Let this matter be listed in the monthly list of January. February kar do. None for the parties. February list. February.
This is against the state of West Bengal. But a partial amount I have got pursuant to the earlier order of 19th of September. After the division bench has affirmed the award. 37.
week. They're not here. What's the point?
That is the only difficulty, but award is of 2006. But I'll get the money, my lord, only.
They have to be here to give you the money.
May I pray, my
Next
lord?
Thursday?
Reserve Bank of India account can be kept attached, my lord.
Next Thursday.
Next Thursday, my lord. Well, let it appear in the daily list now, my lord. Now, today, since your lordship is...
we are trying to take...
I'll give a notice to the...
Give a
other
notice
side.
to him.
Kindly one line, my lord.
None appears for the
judgment debtor state.
Judgment debtor state. Learned counsel for the learned senior counsel for the
award holder
shall serve a notice upon the judgment debtor. Let this matter be listed on Thursday.
Thursday.
None for the parties. In the interest of justice, adverse orders are deferred. Let this matter be listed in the monthly list of February. क्या इधर आइए same order.
Your Lordship, in item numbers 85 and 86, I appear for the award holder, Your Lordship.
Yes.
This is an two execution applications. EC 221 of 2017 is execution of an interim order passed in my favor, and EC 446 of 2018 is from the final award, Your Lordship. This the execution was dismissed in the year 2024. Thereafter, we filed an appeal. The dismissal was set aside, and the execution application was revived. Dismissed because the execution application was filed by one Patrick's, and thereafter it amalgamated into a company called B&K Securities. The merger we hadn't recorded in the execution application, which is why it was dismissed. The dismissal was set aside by an order dated 2nd of May 2025, and the execution application was revived, Your Lordship. There are some interim orders in the execution application. The director of the award debtor was being examined, and the receiver had also been appointed. The receiver had filed the report. Your Lordship, I am praying Your Lordship will fix one day for further examination of the director of the award holder, award debtor, Your Lordship. Your Lordship takes the order dated 28th November 2023. The facts are recorded, Your Lordship.
You have the copy? It's not here.
Yes, you do.
The order, you have the copy of the order?
Yes, it's the part of the folder. Order dated 28th of November 2023 that records that the award debtor was being, director of the award debtor was being examined, and the receiver was appointed. Thereafter, the receiver had filed a report.
So the receiver has auctioned the property?
Yes, the receiver went to the property. Not auction the property, Your Lordship. The receiver went to the property, filed a report. Thereafter, the execution applications were dismissed, and by an order dated 2nd of May 2025, the dismissal was set aside, and the execution applications were revived, Your Lordship.
Dismissal order set aside by order dated?
Order dated 2nd of May 2025. in APO number 79 of 2024 and APO number 77 of 2024.
इसमें ऑर्डर्स नहीं होते हैं सारे.
Your Lordship, if I may hand over a copy.
Restoration order is not here. इसको up to date कराओ ये. Take down. Learned Counsel for the award holder states that in APO number 79 of 2024, read with EC 221 of 2018, an order has been passed on 2nd of May 2025, wherein the which was the order by which it was
Dismissed 12th of March 2024.
wherein the order dated 12th of March
24, Your Lordship.
2024 has been set aside, right?
Yes, Your Lordship.
Has been set aside. Full stop. The execution petition has revived. It has revived, right?
Yes, Your Lordship. That is recorded in the order dated 2nd of May. In the third page, Your Lordship, the second paragraph.
Yeah. Stands revived. Full stop. Learned Counsel for the award holder states that the award debtor has been partially examined. Full stop. She prays for further examination of the award debtor. Full stop. Let the award debtor, Mr.
Director of the award dated, yes.
Director of the award
Lordship,
dated,
one Mr.
Rajesh Goenka. Rajesh Goenka.
Rajesh Goenka, yes.
Remain present for further examination on डेट दे दो जनवरी का. ठीक है. Learned Counsel for the award holder shall communicate the server copy of this order upon the award debtor for necessary compliance.
Before your lordship takes up the next matter, may I just mention item number 83? I could not enter the link, my lord. There's some technical glitch, my lord. 83, my lord, there was a direction upon the award debtor to be present in court, but on another date in the month of August. So on that day, the matter did not reach, my lord. Today, the matter was taken up. So they are naturally not present. If your lordship fixes
Why they are not
a date,
present? They should have been present.
I don't know, my lord, why they are not present, because a warrant of arrest was issued upon them because they were absent. So there
So
was
let that be executed. The warrant of arrest.
no, they took they appeared and they surrendered before the honorable. Kindly take up the last order, my lord. Once, my
You
lord.
should have been here, sir. Sorry, not today. Item 83.
No, I am. My lord has kept the matter in the monthly list of February. Then my lord will kindly keep it another day, my lord. I will give a
Not
letter
today.
to the.
Don't keep it on monthly list of February 83. Not today.
Not today. I'm really grateful to my lord. 83. Yeah, 83, right, Mr. Roman. Let it be. Not today, give a notice.
Grateful, Your Lordship.
Monthly list, February 87.
I'm the petitioner, my lord. On the last occasion, my lord, there was a warrant of arrest against the directors of the judgment debtor, my lord.
Not executed till now.
Not executed, my lord.
We'll wait.
And that's
Your Lordship, I'm appearing on behalf of the. Your Lordship, may I take the leave for appearing virtually, Your Lordship?
Yes.
Your Lordship, I'm appearing on behalf of the award debtor.
Yes, a warrant
129.
has been issued against him.
Your Lordship, in this matter, item 87, Your Lordship, the settlement talks are going on.
no, my lord.
No settlement talks. Is appearing here saying no settlement talks.
Your Lordship, this is item Saraf
87.
Infra.
Saraf
87.
Infra. Yes, yes, madam. Yes.
No, Your Lordship, I think there is some confusion because the settlement talks are going on, Your Lordship, and even if Your Lordship sees the last order, Your
He's
Lordship,
probably
they have
appearing in
filed.
item 87, not
87.
88.
Oh, that's in the monthly list of February, madam. 87.
I apologize, Your Lordship.
88, my lord. I'm the petitioner, my lord. Award was passed, my lord. Money not paid. The judgment debtors did not allow themselves to be examined, my lord, for which I
Give some more time.
No, that's my
Learned counsel for the award holder states that warrant of arrest has been issued on the previous. What is the date?
on 25th July 2025, my lord.
On 25th July 2025. Full stop. It is noted that till date, the warrants have not been executed. The officer in charge of the current concerned police station shall ensure execution of the warrants. Let this matter appear after 6 weeks.
As my own teams.
You communicate with the.
I'll communicate the order.
Okay. My lord, in item number 89, it has a checkered history. It's a very old execution application wherein receiver was appointed to take possession of the hypothecated vehicle. Receiver visited sometimes in 2019 and the award debtor, they submitted that they have sold off the vehicle. However, my lord, receiver filed a report to that effect and thereafter direction was given upon the award debtor to file their affidavit of assets. In the affidavit of assets, they have disclosed another freehold asset, which is an excavator. Pursuant to that, receiver was directed to take custody of that freehold asset in satisfaction of the claim. Receiver has thereafter taken custody of that asset, and since 2019 end or December, January 2020, the asset is still lying with the receiver's custody and in the parking yard. Obviously, the parking yard has been arranged by the financial creditor, but it is in the custody. Thereafter, well, some way or the others, the matter could not be taken up, or when taken up, receiver did not appear. Ultimately, a direction was given to serve the receiver as well as the other side. So we have served the receiver. This is sometimes in March 2025. This is the affidavit of service.
Call the receiver next time so that
Yes,
we pass
my lord,
on
what I was just
substantive order.
beseeching that if my lord keeps it sometimes next week,
Next
I
week.
will. Otherwise, my asset is
Not
depreciated.
today, next week.
Next week. My lord, any date then?
Next week, the next Thursday.
Next Thursday. My lord, the affidavit of service.
What's the point?
Very well, very well. Then I'll submit it on the next. I'm so grateful.
So that we pass a substantive order.
Very well.
Something will be done, otherwise nothing will be
Exactly,
done.
the asset is depreciating. I'm so grateful.
Milord, I am appearing on behalf of the judgment debtor in this matter. Milord, the section 34 is already appearing in your lordship's list as item number
Judgment
OD
debtor.
30. Yes, that is my section 34. And we have
None
secured
for-
the money, Milord. So
None
your
for,
lordship can keep this, Milord, later.
none for the petitioner. Let list in the monthly list of February. Money secured, right?
Yes.
91.
I'm appealing for the award holder, Lord.
Yes.
34 is definitely pending in your lordship's list itself, Lord.
We can secure the order.
You have secured it.
We can.
No, they have not secured it.
No, we can. I'm
They can secure.
Let them secure the amount. Deposit
How?
the amount here.
You'll deposit the amount?
4 weeks time. 5 days.
So for execution petition is concerned, Lord, we have said in our tabular statement, 1,38,79,676.
Sorry?
This is 1,38,79,676. That is column 7, the amount. Column 10 the same amount. That's up to 2019. Interest calculated.
For
up
the
to-
time being, the lordship
Let-
kindly directs that much
Very
that
good.
was to be deposited. And
How much will you deposit? You tell me.
the amount is
How much is the amount?
1 crore
38 lakhs.
1 crore?
38 lakhs.
38,79,676.
Roughly 1.38 crores.
You are paying for the state.
And just because of the kindly gives us 6 fixed terms, that will be safe for now.
Learned counsel for the respondent state states that they are ready and willing to deposit the amount of rupees 1 crore 38 lakhs within a
As, in
period
the, as mentioned in the execution.
as mentioned in the execution application. Let's give the exact figure. What is the exact figure?
138,
138,
79,
79,
676.
676. An amount of so and so within a period of 6 weeks. Let this matter be listed in the monthly list of February. March. Undertakes to secure. Learned counsel for the state undertakes to secure.
Undertaking your also kindly, because that will be my undertaking. I'll be communicating. I'll give it to my. I'll be communicating.
Learned, फिर ऐसे कर देना. Learned counsel for the state states that he shall be securing the award holder to the tune of such and such amount as mentioned in the execution petition. He seeks and is granted 6 weeks time to do the needful. List in the monthly list of March. ठीक है 92
92.
monthly list, none for the parties.
Lordship 93, I appear on behalf of the award holder. Lordship, on 25th July 2025, Honorable Justice Shambhashaka was pleased to issue warrant against the award at number 1. Lordship, we have put in the requisites as was needed in the order. Lordship, the warrant was not executed. He was not even brought. Lordship,
Take down. Learned counsel for the petitioner, the award holder states that this court-wide order dated
Lordship, 25th July 2025.
25th July 2025 had issued warrant of arrest against the award dated number 1. Full stop. Till date, the compliance has not been done.
Lordship, a communication to that effect was also given to the Deputy Sheriff Office.
Has been done by the concerned police station. Full stop. it is hereby reiterated that the warrant of arrest shall be executed. The concerned police station shall ensure. The address is of here.
Lordship, the
We have
address is
put
of
it-
Nischindapur. We have communicated it to the client, to the deputy sheriff as well. Lordship, the police station is Nischinda Police Station, Sahib Bagan, Samabiapalli. Pin code is 711205.
The concerned police station shall ensure that the warrant is executed. Compliance report shall be filed before the next date. Give a date.
Much obliged, Your Lordship.
दावा दे दो चेफ तक. We'll give a longer time, 6 weeks.
Lordship, 6 weeks.
Date बता दो.
Date
29 January.
obliged, Your Lordship.
My lord, I appear on behalf of the award holder in this matter. My lord, by an order dated 21st February 2025, Honorable Justice Shampa Sarkar had issued warrant against judgment data number 1 and 2. The sheriff has to file a report in this matter.
रिपोर्ट आया क्या? सेम ऑर्डर करो इसमें. सिर्फ डेट चेंज हो जाएगा. By order dated 21st February 2025, warrant of arrest was issued. इसमें एक और कर देना. The SP, the Superintendent of Police, Prayagraj, Uttar Pradesh, shall ensure that the warrant of arrest is executed. Full stop. The concerned police station, the concerned officer in charge, Nawabganj Police Station, Prayagraj, Uttar Pradesh, shall make all endeavors to get the warrant of arrest executed. Report to be filed before the next date. All right. Next.
My lord, this is my execution petition by an order dated 28th March 2025. Fresh warrant was issued against judgment letter 1 and 2. The sheriff has to file a report.
Fresh warrant means?
My lord, the warrant was extended. Previously, the report was incomplete.
इसमें वो जो orders है ना, you have to deposit the fresh requisites also.
My lord.
उसमें सब में डाल देना requisites to be deposited. ये order करना. ये ठीक है. ठीक है ना. The rest of the matters will have more. Another is Kotak, 96. What is
My
it?
lord, my lord, if I may, my lord, the service in this matter is not complete. I'm praying for a substituted service.
The award holder seeks and is granted 3 weeks.
3 weeks, ma'am.
3 weeks time to effect service upon the award debtors. List after 4 weeks.
98, my lord, in this matter, my lord, there is a direction for filing bank guarantee. Okay, for the judgment award debtor. We have deposited the bank guarantee, intimated other side.
But the 90 lakhs, the bank guarantee and 90,000
The rest-
deposited. Plus of 90. I don't know 98. I think all right. 96.
96 is going on. Rest of the matters on next week.
Grateful, Lordship.